कांड परमिशन है ये फर्स्ट अकेले है इसका
आउट ऑफ लिस्ट
ignorance लेट्स बी इग्नोर या आइए डिफेक्ट कर लेते हैं उसका ignorance के लिए आइए डालना है उसी के लिए
आप इनके पास नहीं बोलते हैं टेस्ट करने के लिए आप बोलते हैं आपको इन्फॉर्म करते हैं तो नहीं समझ में आता you should give it to them why do you need to unnecessarily mention it it will be listed
from the daily list under heading for orders with defect item 1 FA 100 of 2024
Your Lordship, I need 3 weeks time.
you have filed an IA for early hearing in a defective petition and now you are seeking 3 weeks time
Some defects are still pending. We will try to remove the defect within 3 weeks.
KFA number 100 of 2024 with IA number 11109 of 2020. This appeal is defective. The learned counsel for the appellant prays for and is allowed. Time till 17th of February 2024 to remove the surviving defects. So far as IA number 11109 of 2024 is concerned, it is sufficient to observe that the appeal will be listed immediately. The appeal is directed to be listed on 19th of February. IA closed.
item 2 FA 117 of 2024
there was a playing for the game to the time for the reporting the
Time till 17th February is allowed to the petitioner to remove the surviving defects. Post on 19th.
item 3 FA 126 of 2024
One defect is same order.
under heading for orders item 4 SA 531 of 2017
there's a short
In this case, we don't.
item 5
He has
SA
prayed
2
for a
of
passover.
218
But I am for the appellant minutes.
So he's praying, he's for the respondent, he's praying for a Passover. What should we do about it? You're praying for a Passover, correct?
it's short possible it's only for one case
आपके हिसाब से टाइम नहीं होता है. Case call out for your counsel is not there, it will be taken up at 1 o'clock.
item 5 SA 2 of 2018
playing for short
Say 1 बजे.
In this case, notice have been issued.
We do not know. Passover हुआ 1 बजे.
item 6 SA 118 of 2020
acknowledges the appellant. Nobody appeals. 1950.
Item 7, SA 90 of 2022.
The Lordship, by last orders, you have filed a fresh memo of parties.
So,
There are 4 more IAs that are pending.
what are those ideas?
The Lordship, the first one is for limitation. IA number 12044 of 2022.
What about others?
Your Lordship, Your Ladyship, there was a delay of 12 days. We have mentioned in para 2
So,
of the IA, and the reason
what
was,
else? What other IA?
Your Ladyship, there are 3 more IAs for substitution, that is IA number 7135 of 2024
For
substitution of respondent number 50. He died on 4th March 2024. And
you want to delete his name?
we have substituted Your Ladyship, the name of his IAs.
Already substituted means? Then why this IA has been filed? You are seeking substitution or you have already substituted?
No, Your Ladyship, we are seeking substitution.
Expunging the name of what about other IA? 8622?
IA number 68622 of 2024, substitution of respondent number 31. We are seeking substitution.
What else?
Then IA number 11837 of 2024, that is the substitution of respondent number 32.
Nobody has entered appearance. Notice was ever issued.
No, Your Ladyship.
Notice was never issued earlier. CKSA number 90 of 2022. Learned counsel for the appellant submits that. इनका नाम दीजिए. Give your name.
Kashyap.
Sorry, write it and give it. And IA number 12044 of 22 has been filed seeking condonation of delay. And IA number 7135 of 2024, IA number 8622 of 2024, and IA number 11837 of 2024 are in relation to substitution of deceased respondent number 50, 31
32.
and 32. Issue notice to the respondents except respondent number 50, 31 and 32 who are reported to have expired. Notice to respondent number 50 to the legal heirs and proposed legal heirs and successors is to be issued with respect to respondent number 50, 31 and 32. The requisites under ordinary process be filed by 31st of January. Post on 24th March awaiting service.
more time may be given for filing of requisites.
I've given you sufficient time.
4 weeks.
31st time. And it's just the ordinary process. Let the records be called for from the concerned court. Let this order be communicated through fax. Any execution pending?
Under heading for admission, item 9, FA 157 of 2024.
This is the first time, Lord, my original suit was dismissed by the current court below. So,
Dismissed on what ground?
ground that both the parties have sold the land, so there is no any question of partition. So, my Lord, our submission before the current court below that I have sold, but only meager area of the land for my own livelihood.
This is under the heading for?
Admission below. One IA is pending. I am not pressing that IA because
IA is for 4 days.
for delay, but there is no any delay. In apprehension that there was delay, so
In
I
time.
Yes, Lord.
FA number 157 of 2024 with IA number 13346 of 2024. The learned counsel for the appellant submits that although although interlocutory application has been filed seeking condonation of delay, but as per office note, there is no delay. Considering the office note, he submits that he does not want to press the interlocutory application. Accordingly, IA number 13346 of 2024 is dismissed as not pressed. And let this first appeal be admitted for final hearing. Issue notice to the respondent number, to all the respondents.
Yes.
Through ordinary process, except respondent number 1, or through ordinary process and registered covered. Notice upon ordinary process will not be issued so far as respondent number 1 is concerned. The requisites be filed by next Friday.
Yes.
Post this case on 24th of March. Let this order be communicated through fax.
Obliged.
Item 10, FA 3 of 2025.
Yes.
Sir, this appeal is against the judgment and decree in original suit number 414207. In this, the unity of possession and title is in question.
FA 3 of 2025. Admit. Call for records from the concerned court. Let notice be issued to the respondents. Under ordinary process as well as registered cover. खाली ordinary process करिएगा. They are all from Jharkhand.
Yes, all are.
For
There are
which?
93 parties in total.
Only ordinary process for which requisites be filed by next Friday. Post on 24th March under appropriate heading. Let this order be
Lordship
communicated.
reigned for a longer time. Actually, there are
Come,
93 parties.
admit है.
93
Ordinary
parties.
process का notice किए हैं, कोई बात नहीं, आप लगाइए हो जाएगा.
Under heading for hearing,
You
under
have
order.
2 full weeks.
Yes, but
Two
actually
full week.
93 parties.
कोई बात.
Under heading for hearing under order 41 rule 11 of PTC, item 11 SA 235 of 2018.
This appellant is plaintiff and appellant before the court below. Plaintiff filed instituted the partition suit also, but suit was wrongly filed as partition also. But alternative prayer in the relief portion was that the alternative title of the plaintiff be declared over 14 feet into 70 feet of land fully described in Schedule B below, and the plaintiff be put in fast position through the process of the court of eviction of a defendant or any person claiming through them. The case of the plaintiff is the land which is recorded in the name of Daso Sahu, whose alias name is Daso Halwani.
Where is the question of law that you have formulated?
Yes. Page number 7, Lord.
Yes. Read.
Whether both the court below have committed wrong in substantial question of law when the plaintiffs have paid for alternative prayer for declaration of title, when the title of the plaintiff on the basis of transfer in favor of the plaintiff by vendor has never been questioned by
इसका
the.
मतलब समझाइए क्या
Yes.
मतलब है इसका?
इसके लिए बस फैक्ट थोड़ा सा हल्का सा बस क्लियर करना पड़ेगा बिकॉज
आगे क्वेश्चन ऑफ लॉ.
नेक्स्ट बी है whether the defendants never question acquisition of the title in favor of the plaintiff by land by exhibit said, which is exhibit 3 laws. Petitioner purchased the lot. Petitioner is the purchaser lot, dated by the vendor who was admittedly by the predecessor in interest of the suit property.
आपका लैंग्वेज ऐसा है कि हमको समझ ही नहीं आ रहा है क्या? What kind of language is this?
इसके लिए हम बस थोड़ा सा फैक्ट क्लियर करते हैं उसके बाद लैंडेड फर्स्ट अप्रेट को also
Let us see your trial court judgment.
Yes, Lord. केवल थोड़ा सा एक फैक्ट क्लियर कर देंगे अदरवाइज क्लियर नहीं हो पाएगा. बस हम 2 मिनट बस.
ट्रायल कोर्ट जजमेंट से देखिए.
हाँ, ट्रायल कोर्ट जजमेंट में ही दिखा देंगे. पहले एक फैक्ट क्लियर जब तक नहीं हो पाएगा तो क्लियर नहीं हो पाएगा.
ठीक.
Land was recorded in the name of Daso Sahu Daso Halwani.
The suit land.
Suit land also. Daso Sahu.
दासो
दासो साहू.
साहू.
दासो साहू के एक लड़के दोमन साहू और दो उनकी लड़की थी राधा देवी और गौरा देवी.
दोहन साहू.
दोमन साहू.
सोमन.
सब सन राधा देवी
राधा
and गौरा देवी.
गौरा. Yes.
The suit land is lordship 2 कट्ठा 8 धूल 6 धूल की.
इसका क्या रेलेवेंस है?
हाँ, उसका हम इसमें क्लेम किए हाफ ऑफ द लैंड के लिए अपना डिक्लेरेशन ऑफ टाइटल लॉर्डशिप. इसमें
2
गलती
कट्ठा 6 धूर.
टोटल जमीन था 2 कट्ठा 8 धूर 6 धूर की. 8 धूर 6 धूर की. We claim 1 kattha half of the land. So 1 kattha 4.
Who means we means who?
Plaintiff lordship.
Plaintiff is domain.
Plaintiff is the purchaser lordship. नहीं हम वही यहाँ पर ये पार्टीशन सूट होना नहीं चाहिए. गलती से यहाँ पर लोअर कोर्ट में पार्टीशन सूट हो गया है. फिर दोमन साहू एंड राधा देवी who sold the land lot, half portion of the land sold in favor of the plaintiff by registered sale deed on 21st January 74.
Half portion
of the land in the southern portion
sold to
the plaintiff lordship on by registered sale deed lordship
without partition.
25/174.
Without partition.
Yes, without partition. And the same the legal heirs lordship also sold the half portion of the land lordship to defendant number 4 on 9/2/74.
Same property.
No, half portion of land.
Remaining half.
We purchased the half portion of land lordship. And
In an undivided share, how do you purchase half portion of land? Was it earmarked?
No, both they jointly sold the land.
What about Gora?
We are purchaser lordship.
What about Gora? There is one more sister.
Yes, Lord.
So,
Since we are not claiming partition lordship, since wrongly it has been drafted as a partition suit lordship. We are the purchaser. Defendant is also purchaser lordship. Defendant also purchased the half portion of land lordship, and they are only claiming on the basis of adverse position lordship. We purchased on the basis of the registered sale deed on 25th January 74. Thereafter, land was mutated. Rent receipt was issued in favor of the
you purchase half portion.
half land lordship.
Defendant is claiming another half portion.
Yes, lordship. So इसमें बस यही है कि
इन डिफेंडेंट को किसने बेचा?
डिफेंडेंट को ये गौरा देवी बेची. गौरा देवी.
Only Gora Devi.
हाँ, only गौरा देवी. 9/2/74. Exhibit C. Registered sale 3
और आपका एग्जिबिट?
मेरा एग्जिबिट 3 है, गौरा देवी बेच रही है 3 आना डिफरेंट नंबर 4 को 9274 दैट इज एग्जिबिट सी, दूसरा है 19474 एग्जिबिट सी बाई 1 सेम गौरा देवी।
एक सेकंड, ये कौन कौन सा क्वेश्चन भेजी है? कौन सेल डीड बताइए?
हाँ।
गौरा देवी वाला बताइए जो डिपेंडेंट को भेजी।
हाँ वो एग्जिबिट सी है,
डेट
9274
9274 और एग्जिबिट सी बाई 1,
एग्जिबिट बाई गौरा देवी,
एग्जिबिट सी बाई 1
सी बाई 1 है 19474
19470।
ये 5 आना रही है, 5 आना शेयर, 3 आना 5 आना हाफ पोर्शन दोनों को बेच दी, वो बेचिए डिफरेंट नंबर 2 and 3 को।
3 आना 5 आना हाफ पोर्शन कैसे हो गया?
8 आना हो गया हाफ पोर्शन, 3 आना 5 आना हाफ पोर्शन को बेच दिया।
बाउंड्री है, प्रॉपर्टी का बाउंड्री है।
हाँ बाउंड्री मेरा किया हुआ था उसी,
सेल डीड में बाउंड्री है।
हाँ बाउंड्री है। यस
गौरा देवी पहले ये दोनों बेच दिए, डोमन एंड राधा। शी थॉट मेरा प्रॉपर्टी का क्या होगा, वो बेच दी।
नहीं मेरा सबसे पहले फर्स्ट टर्म को बेचे, मेरा जो फर्स्ट आगे वाला जो हिस्सा था मेरा उसमें मेरा शॉप था, और जो पीछे वाला हिस्सा में वो एडवर्स पोजीशन के ग्राउंड पे वो लोग उसमें वो क्लेम कर रहे हैं ओनली ऑन द ग्राउंड ऑफ एडवर्स पोजीशन। वो मेरा रजिस्टर्ड शेड रूट से हम परचेस किए एंड दैट रजिस्टर्ड शेड हैज नेवर बीन असेस्ड बाय बिफोर एनी कंप्लेंट कोर्ट ऑफ लॉ। तो मेरा जो रिलीफ था हम पार्टीशन तो वो था परचेजर लॉट से, वो शेयर नहीं है तो पार्टीशन सूट तो होना नहीं चाहिए, लेकिन जो अल्टरनेटिव रिलीफ मेरा जो मांगे है उसके लिए अल्टरनेटिव रिलीफ के लिए नो issue was framed lordship, no finding was given by the Red Court below lordship.
And these Doman, Radha and Gaura are not party.
No, they are not party because we are purchaser lordship.
And they have left.
Yes, आप बेचने के बाद बोलो छोड़ दिए, they are not party lordship. Both are purchaser lordship. और उसके पहले क्या, पहले हम लोग दोनों के टेनेंट थे डोमन के, हम लोग भी टेनेंट थे, वो भी डिफेंडेंट भी टेनेंट थे। बाद में 1974 में हम लोग परचेस किए, उसके बाद में ये लोग परचेस किए। मेरे पास लैंड को जो थोड़ा सा पोर्शन को वो ऑक्यूपाई किए हुए वो ओनली ऑन द ग्राउंड एडवर्स पोजीशन लॉर्डशिप। मेरा प्लेट में भी हम लोग मेंशन किए हुए माय अल्टरनेटिव प्रेयर इज लॉर्डशिप दैट द इन द अल्टरनेटिव टाइटल ऑफ द plaintiff we declared
You read the case of the plaintiff.
yes lordship,
Page number 13. The suit has been filed
yes
for
track lordship
decree of partition.
degree of partition because both are not co-sharer lordship।
तो फिर आप डिक्री ऑफ पार्टीशन के लिए क्यों फाइट की?
हाँ वो गलती से वो हम गलत हुआ, co-sharer है ही नहीं, पार्टीशन सूट नहीं होना चाहिए। पेज नंबर 30 lordship।
What were the issues framed?
Yes, lordship. Issue, kindly see issue of the trial court lordship. Issue number 5 and 7 lordship. Page number 8, running page number 18 lordship.
Read all the issues.
Yes, lordship. Is the first issue. Is the suit as framed maintainable? Has the plaintiff any cause of action for the suit? Third, is the suit barred under provision of a specific relief act? Is the suit barred for misjoinder of party? Fifth, is the suit barred by law of limitation and adverse possession and ouster? Is the suit undervalued? Seventh, whether there is unity of title and position between the parties in respect to the suit property? Eighth, to what relief any plaintiff is entitled. So, no issue was framed on ground of alternative relief lordship, which we sought lordship. No issue was framed. Kindly see the finding given by the
We are not here to frame issues for you, isn't it? In second appeal, you filed a partition suit. Partition suit में fixed court fees लगता है. Just a moment. Fixed court fees लगता है. Fixed court fees देके एक तो partition suit फाइल करते, right? Now you are claiming a title deed.
Amendment हुआ फिर
Declaration of
It was amended lordship. We also sought for alternative relief lordship. So the Red Court below ought to give any opinion finding lordship on the ground of alternative relief which we sought lordship. Kindly see the finding given by the Red Trial Court lordship, page 32 lordship.
From where do you say that the suit was amended? When was it amended?
Yes, suit was amended lordship. An alternative relief we sought lordship that has been incorporated lordship. It has come also in the order lordship.
So you are not agreed by any of the findings?
No, we are agreed. Kindly see.
Because alternative relief का तो कोई issue ही नहीं बना, correct?
नहीं तो अब देखा जो हमारा डिसमिस करे ऑन द ग्राउंड ऑफ लिमिटेशन that is wrong lord. Can you see para 32 of the Learned Trial Court judgment lord? Running page 33 lord.
Yes.
The parties to the suit cannot be said to be having any unity of title and possession over the suit property, as both of them were separate purchasers of a specific half portion and remain in possession as per their convenience without demarcation of their specific half portion. Since a specific half portion was purchased by the plaintiff, as such, no any decree for declaration of the share of the plaintiff is required to be passed. So the Learned Court below is also admitting. I'm sorry. Nor any demarcation of the share of the parties is required to be made. Both the parties have exercised individual and separate acts of possession, and the same was never as joint and co-owners. The parties to the suit therefore never came into possession of the specific portion purchased by them and continued their possession held by them as tenant of their vendors. The loss of possession by the plaintiff as on 12/3/1995 is disbelieved, and as such the limitation of recovery of possession of the purchase portion by the plaintiff would have started running from the date of purchase of southern half portion by him on 25/1/1974. The relief of recovery of possession of 17 feet by 14 feet land as described in the Schedule B to the plaintiff is accordingly barred by limitation. The plaintiff as such is not entitled for any relief and possession for unity of title and possession in found in favor of the parties to the suit. Both these issues are accordingly decided against the plaintiff and in favor of the defendant. So the ground taken by the Learned Trial Court lordship on the ground of limitation is not correct lordship. वो कह रहे हैं कि जिस दिन से हम परचेस किए 1974 उसके अंदर एज पर आर्टिकल 65 ऑफ द लिमिटेशन एक्ट हमको 12 साल के अंदर में फाइल करना नहीं था. दैट इज नॉट द लॉ लॉर्डशिप. लॉ इज लॉर्डशिप जब हम एडवर्स पोजीशन का वो क्लेम करें तो उनको बताना पड़ेगा कि विच डेट वो एडवर्स पोजीशन का क्लेम करें. अगेंस्ट
The court has not recorded any finding of adverse possession in their favor.
यस एडवर्स पोजीशन के ग्राउंड पर ही किया.
उनको कहाँ ही कोई रिलीफ दिया
नहीं.
उनका तो एडवर्स पोजीशन डिक्लेयर भी नहीं किया.
नहीं
कहाँ है डिक्लेरेशन?
नहीं अपरेट कोर्ट भी किया है. अभी ये लिमिटेशन का ग्राउंड ही हम दिखा देंगे रूलिंग जजमेंट से. जो रूलिंग जजमेंट जो बोलता है ऑनरेबल सुप्रीम कोर्ट डिसाइडेड लॉर्डशिप जो एडवर्स पोजीशन के ग्राउंड हो जब तब स्टार्ट हो जब वो क्लेम करें किस डेट से हम एडवर्स पोजीशन में क्लेम कर रहे हैं. तो 19
कहाँ है cause of action? What is your cause of action and what is their cause of action? There is no. The court says that there is no demarcation of property. How do you say that adverse possession has been declared in their favor? Unless the property is demarcated, how the adverse possession can be decided?
Because they claim their case lordship, they filed that WS lordship and claim only on the basis of adverse possession they are claiming lordship. Para number 23 lordship, para number 23 of the WS lordship. They may have read of the para 23 lordship of the WS filed by the defendant lordship. The defendant number 1 having remained in possession over the area purchased by him as well as the land lying to the east of the plaintiff's shops upon municipal one openly asserting right of ownership to the knowledge of the plaintiff and other person of the locality for long over 12 years and by long and
You say your plaint was amended?
Yes, lordship.
This relief is as per the amended plaint, which is mentioned in para 1 of the judgment.
Yes, lordship. The plaint was amended, lordship.
Plaint was amended.
Yes, sir.
You were seeking declaration of your right, title, interest, possession so far as your portion is concerned.
Yes, lordship. And disposition of the defendant, lordship.
They have entered into your property.
Yes, lordship. Only on the ground of adverse possession they are claiming, lordship.
Where is the declaration of adverse possession in their favor? Tell us.
Yes, they should file the cross objection or because they have not filed cross objection, lordship. And the Learned Court below only on the ground of first trial court, lordship, dismiss my case only on the ground of limitation, lordship. And kindly see the appellate court judgment, lordship, the first appellate court judgment, lordship. Because both we are purchaser, lordship, and the Learned first appellate court, lordship, hold that we are tenant, lordship. We are landlord and defendant was tenant, lordship. Kindly come to para 36 of Learned first appellate court.
Any cross appeal has been
No,
filed?
they have not filed any cross appeal.
You say that the court has declared adverse possession in their favor. Kindly show me the finding.
Yes, lordship.
Where is that finding of the Learned Trial Court of adverse possession in their favor?
Learned trial court only on the ground of limitation dismiss my suit lordship.
Okay.
And first appellate court lordship, we can come to page number 53 of first appellate court judgment lordship. Para number 36 lordship. Reading page 53.
Yes.
Considering the case of both the parties and discussing the evidence adduced on behalf of both the parties, oral and documentary evidence, I find and hold that the plaintiff failed to prove the unity of title over Schedule A property, and the plaintiff has also failed to prove that, and the plaintiff is also not entitled for alternative relief for declaration of title, as the plaintiff has not pleaded in his plaint that the defendant is in possession their purchased property, and also this suit is not filed under the provision of Jharkhand Building Rent Control Act as admitted by the plaintiff in Part 6 and his deposition Para 6 and cross examination in Para 29, and the plaintiff independent witness PW6 Para 12 the defendant was tenant of the original owner. Since the relief for the recovery of possession is seeking by the plaintiff over Schedule B property and the plaintiff is not in possession over it, therefore the plaintiff is also not entitled to the relief for declaration of his title. And
Yes.
this
Now you claim, you see, the finding is that you claimed that the property was under possession of this defendant because he was the tenant of the original owner. Correct?
both were tenant also. हम लोग
Maybe
tenant
both
थे,
were tenant, we
हाँ,
don't
दोनों-
bother
दोनों
about
tenant थे,
it.
बाद में हम लोग purchase किए.
ठीक है? Now you want, there is two portion of property. They were also tenant.
Yes, doctor, they were also tenant.
They were also tenant
They
with,
purchased their
with
house
respect to their property, in which you were the landlord. Sorry.
No, since
You see, the landlord had given the property for tenancy. You purchased your portion or you purchased his portion also?
no, I purchased my portion lordship. They purchased their own portion lordship.
Then
But
why did you say that they were put under they were tenant, and you have not even as per the finding recorded by the learned appellate court, you have not even pleaded that that defendant were in possession of their property. It was not your case.
No, that is my case lordship.
Where is your plaint?
Yes. इसके बस एक दो पैराग्राफ और फर्स्ट अपडेट कोड का कंप्लीट हो जाएगा. Issue number 3. Issue number 3 has been decided in our favor. Since the plaintiff has pleaded in plaint Para 6 that the defendant was a tenant of Daso Halwai, who is owner of the property, and it is also admitted by defendant in his pleading Para 13 and 14. As such, the defendant not take the ground the adverse position because his capacity as per his admission as a tenant and as per provision of section 116 of the Evidence Act read as follows: no tenant of immovable property or person claiming through.
So there is a declaration that he was the tenant over the property.
Both were tenants. Or the land first applied only.
We do not know. You say that it has been decided in your favor. He has been declared as a tenant over the property involved. Isn't it?
The land court failed to understand the fact law. See, that
You
is why.
have also failed to understand the fact. You say that this issue has been decided in your favor.
Can you see? Hence, this issue is decided in favor of the plaintiff and against the
आपके
defendant.
लाइन से क्या होगा? अगर उसका टेनेंसी हो जाएगा तो आपका क्या होगा?
हम तो परचेस किए सूट जो हम
Purchase किए हैं. If you become the purchaser, then you become the successor you succeed as a landlord. You cannot evict him by virtue of this suit. You have to file a suit for eviction under BBC Act because he continues to be your tenant, isn't it? He has been declared as a tenant. लैंडलॉर्ड अगर प्रॉपर्टी बेच देता है तो क्या सब the purchaser will evict him? No. The purchaser buys the property with tenant. So he's your tenant. अब उसको eviction suit फाइल करिए on default. आपको रेंट नहीं देता है. You get it?
नहीं रेंट वो he is not my tenant और वो illegally उस पोजीशन पर
Finding तो हो गया ना that he is a tenant. Whether he is your tenant, not tenant, we do not know. He is contesting this suit. He got himself declared as a tenant over the property.
अगर वो tenant claim करे, there must be a agreement between that
कहाँ?
both the landlord and tenant lords.
कहाँ और एग्रीमेंट का
हाँ,
जरूरत
कोई
है?
agreement नहीं है किस तरह का.
तो फिर
तो लैंड ट्रायल अपलेट कोड बोल रहे हैं नेक्स्ट में हमको स्पेसिफिक झारखंड बिल्डिंग रेंट कंट्रोल एक्ट
naturally, because there is a declaration that he is your tenant. बताइए.
नो सिंस ही इज इन इलीगल पोजीशन ऑफ माय
आपके देखिए रिकॉर्ड से बाहर वाली बातें मत सुनाया करिए. एक तो पार्टीशन सूट फाइल कर दिया आप.
वो गलती
और भी क्या क्या गलती की है इसका भी तो बताइए ना. Do you say that issue number 3 has been wrongly decided? If this has been wrongly decided, then the suit was not maintainable. If this issue number 3 has been rightly decided, then the suit was not maintainable because he is your tenant. फिर adverse possession की क्या बात है? There is no finding of adverse possession. There cannot be any adverse possession qua tenancy. क्या चीज का liberty?
नहीं बिकॉज़ द लैंड अपलेट कोड
I don't need to give you any liberty. Liberty is under law. He has been declared as a tenant. Then there is no finding of adverse possession in his favor. सेकेंड हाफ में समझ के आइए. ऐसे हम लोग सेकेंड अपील इस तरह से नहीं.
बिकॉज़ डब्ल्यूएस में वो फाइल किए थे पैरा 20
आप बिकॉज का कहानी मत सुनाइए प्लीज. देयर आर टू कोर्ट्स. देयर आर फाइंडिंग्स रिकॉर्डेड इन 2 कोर्ट्स, राइट?
नहीं उसमें हम जजमेंट दिखा रहे लैंड जो फर्स्ट ट्रायल कोड जो अपना जजमेंट ऑन द ग्राउंड ऑफ लिमिटेशन एप्लीकेबल नहीं होगा.
उसका छोड़ दीजिए ना. लिमिटेशन का एक कहानी कहाँ है इसमें?
नहीं
There is a declaration of the first appellate court that he is your tenant. So, यही है ना declaration that he is your tenant. Go and file eviction suit. We do not know. उसके बाद tenancy वो deny करेगा. हम लोग क्या ही बोल सकते हैं?
I am permitted to file the eviction suit.
I don't need to give you any permission. Permission is already there under law. कोर्ट के परमिशन से लॉ थोड़ी डिक्लेयर हो जाएगा. दिस इज ऑलरेडी देयर.
Again they will count limitation not because this payment.
क्या चीज का लिमिटेशन? टेनेंसी आपको रेंट नहीं दे रहा है, इसमें क्या ही लिमिटेशन लगेगा?
नहीं
एवरी मंथ पेमेंट इज अ कॉज ऑफ एक्शन.
नहीं हम लोग के बीच में टेनेंसी हुआ ही नहीं है कभी. टेनेंसी हुआ ही नहीं कभी भी. Only on the since he is illegally occupied my space lordship and only on the ground by adverse possession lordship.
I don't know where you say adverse possession. Did he claim? Where is the plain and written statement?
Yes.
Give me the plain and written statement. इसका चेक करिए तो कोई और भी अपील फाइल हुआ है. This is civil appeal number 33 of 2014, which has been decided by District Judge Roman 3 Hazaribagh. Title Partition Appeal. Plain written statement दीजिए. नहीं इस पे कोई और अपील फाइल हुआ है. ये क्या है?
Plate.
प्लेट. और ये क्या है? अमेंडेड प्लेट.
amended उसका type कर दिया.
कोई अपील नहीं दिखा रहा है.
इसको आप दे दीजिए, आप सेकंड हाफ में.
एक ही
क्योंकि टेनेंसी की ये कहानी कहाँ से आ रही है?
नहीं,
From
हाँ,
where
नहीं,
is he coming
नहीं हम लोग
that he is the tenant over
नहीं
the
ये
property?
गलत फाइंडिंग जो लैंड फर्स्ट अपडेट को जो बोर्ड है द प्रिंटिंग आइडेंटिटी द डिफरेंट वाज द टेनेंट ओवर द प्रॉपर्टी ये गलत फाइंडिंग होगी हम लोग
Yes.
दोनों कोई दासू साहब के टेनेंट थे हाँ, मेरे वो कभी भी टेनेंट नहीं रहे दिस इज
तो
रॉन्ग फाइंडिंग
क्वेश्चन ऑफ लॉ तो फ्रेम करना पड़ेगा.
यस लॉर्ड
record मंगा के question of law. That
Yes,
would be
doctor.
better because plain and written statement is required.
Yes, yes, yes.
और आपका ये आधा फटा हुआ डॉक्यूमेंट से नहीं देखेंगे. देखिए, second appeal number 235 of 2018. The learned counsel for the appellant has submitted that the records of this case be called for from the concerned court, as the plain and written statement is required to be perused by this court. He submits that it was never a case of either party that one or the other was tenant
Yes, doctor.
under one or the other party.
Yes.
He submits that as per the plain and written statement, the property belonged to
Daso Sahu.
Daso Sahu, Sahu,
Sahu. S-A-H-U.
S-A-H-U, and both the plaintiff and the defendant had purchased the defendant
Purchased.
number 3.
Exhibit 3, Lord.
Defendant number
Defendant number 4, 2, 3 and 4, Lord.
both the plaintiff and the defendant had purchased the property through registered sale deed.
Yes.
And the purchase was, the sale deed included the entire property, but there was no partition, but the share was not earmarked, correct?
Yes.
That the records be called for from the concerned court before framing the substantial question of this case. Let the order be communicated through this. इसको लीजिए. अगर तीसरा केस बना दिया है कोर्ट तो देखना पड़ेगा.
हम लोग से गलती हुआ पार्टीशन सूट का मैटर ही नहीं गलती से.
Next date.
नेक्स्ट डेट इसको रखिए. Tenth of February.
Item 12, second appeal 500 of 2018.
Yes, appellant. Yes, please. Yes.
Judgment of reversal, it is valid. I was the plaintiff and suit was decreed in my favor. And defendant preferred an appeal and judgment was trial court was sentence. Mainly on the issue, could I take a lordship?
What substantial question of law have you framed? What substantial
The
question of
substantial
law?
question of law is lordship. That is why I was going to take a lordship to the issue framed in the trial court.
I just want to see what substantial question of law have you
Substantial
framed.
question of law is,
Where is it?
with regard to,
Where is it? Where have you framed?
सही की बोलছি আমি.
You read your substantial questions of law.
Substantial question of law is not sure. One of the substantial question of law is that with regard to Exhibit A, there was no issue framed by the trial court. Or that was with regard to unregistered deed of gift. There is not whisper even in the issue portions, issue frame. কোথায় লিখেছে? Page number 30, Lordship, of the trial court judgment. On the basis of pleading of both the parties, following issues have been settled.
What was the case of the plaintiff?
Case of the plaintiff was that he has right, title, interest over the property in question, and suit for declaration was filed because the defendant, basing on a particular paper, that is Exhibit A, saying that we are the property owner, so they
You were
started
seeking a
disturbing.
you just read your para 1 of the judgment, trial court judgment.
Trial court judgment.
Yes, you were seeking declaration of
Para
right,
one.
title,
The
possession.
plaintiffs have brought the suit for declaration of title and possession over the suit land, item number 1, address B, for restraining the defendant from interfering with the possession of the suit land and for declaration of the deed of gift of 1560 is void, illegal. This is the thing. This document has been relied upon by the defendants, appellant in the court below, and basing on this, they are holding. They are saying that they are.
You see, it was your suit. You wanted
That is
an
their case.
unregistered document to be declared as void.
Yes, because
Why did you go for a declaration of an unregistered document as void? Unregistered gift deed.
unregistered deed.
Why did you need a declaration?
Because the defendants are standing on this deed, saying that that is a valid document and we have acquired right, title, interest over it.
What is-
Plaintiff has got nothing on it.
What you wanted declaration of a right, title, and interest.
Right, title, and interest.
They would have claimed they would have filed a written statement on the basis of this gift deed.
They have filed it.
Then you are seeking a declaration that an unregistered gift deed in connection with this property, immovable property, is void. Why did you go for a declaration of an unregistered gift deed?
So
You could have simply gone for a title declaration.
Declaration can be played in the print. Declaration with regard to my title and
Yes,
he has
that
no title.
title is already there. That declaration you are already seeking. You are seeking declaration of right, title, interest, and
No,
possession
the
over the
plaintiff
property.
brought the suit for declaration of title, possession over the suit land, restraining the defendant from interfering with the possession of the suit land, and for declaration that the deed number so and so is void, illegal, this and that. So my suit was for the declaration that I have right, title, interest over the property in question.
Right, title, interest, and possession also.
Possession also over the property in question,
Yes.
and that has been declared in my favor. Now, the only remains what the defendant case was that they are having right title instead of the plaintiff, but we have right title, interest, possession over the property in question, particularly because of the document that is Exhibit A, which is unregistered Sada deed of gift, which had been given by one Shivan to one Jitni. Now, kindly come, that is why I was taking your lordship to page number 13 of the trial court judgment. Yes. On the basis of the pleading of both the parties, following issues have been settled for deciding the real controversy between the parties. The suit is maintainable as framed from have the plaintiff cause of action for the suit, whether suit is barred by limitation, whether suit is barred for non-joiner of the parties, have the plaintiff life, title, interest, whether plaintiff are in possession of the suit property, whether plaintiff is entitled to a decree.
They have given you the declaration of right, title, interest, and possession. What else do you want? They have given you the declaration of right, title, interest, and possession.
No, I'm trying to satisfy your lordship.
No, I just want to know.
Yes.
There is a property. You want a declaration of right, title, interest and possession qua that property. Any person may be claiming that property by whatsoever document, right? So you made them defendants also, who were claiming that property by virtue of some gift deed.
Appellate court has decided that. That is why my submission, because there was no issue involved in it, and by that issue has been taken up by the appellate court and decided that the defendant has right, title, interest. So
By virtue of that gift deed.
by virtue of that document, and the judgment of the trial court is set aside. This is the finest question of your lordship.
What is the point of determination by the appellate court?
That is why.
What is the point
So
of
your lordship has not seen a single line or single word with regard to the document in question, which is the main argument on the of the defendant. And
The trial court you won.
now kindly see me not page.
That was
page-
an ex parte judgment,
Huh?
isn't it? Trial court judgment was an ex parte judgment. It was ex parte against defendant number 1A
No,
to
no,
1A.
no, no, no. Trial court contest हुआ है.
By defendant number 2 and 2D.
हाँ, two. Kindly see me page 25 of the trial court judgment.
It is only against defendant number 2 and 2D.
Kindly see me.
An ex parte against 1A to 1A,
Yes,
2D
sir.
to 2A.
The suit be decreed, the same is decreed on contest against defendant number 2 to 2D and ex parte against 1A, 1H, 2E, 2F with cost.
Who was the appellant?
Who was the appellant?
The contesting defendant 2 to 2D were the appellants.
Now kindly see me, Lord, the appellate court's judgment, which has set aside my अब appellate court का judgment देख लिया जाए. सेट असाइड कर दिए हैं हमारा ट्रायल कोर्ट का जजमेंट को.
You read para 12. You first tell us the point of determination and then read para 12.
Point of determination is whether that appellate lower appellate court
आप पढ़िए ना please para 12 से पढ़िए.
para
12 of the appellate court judgment.
appellate court judgment.
Internal page 23.
The learned court below ought to have
Internal
held,
page 23.
ought to have held
That is not matching. Internal page 23 of the appellate court judgment.
internal के 23 होता है ट्रायल कोर्ट जजमेंट.
Appellate court judgment.
तो बहुत इंटरनल Internal page 23 of the appellate court judgment. On both the sides, larger law prayer for the appellants, submitted the present appellant arises out of the judgment so and so, so and so, so and so. The defendant plaintiff, that on adjudication, plaintiff's position, when title possession of the suit land be declared and possession be confirmed, that it is declared that deed gift dated 11/5/16 is void, illegal, concocted, forged, fabricated, and never ever acted upon acted upon. The right, title, interest are not affected by virtue of the deed of gift, and the plaintiffs not being party to the documents not bound by that it is found the plaintiffs have disposed of plaintiff has been dispossessed from the suit land in honor pursuant to the pendency of the suit. Petition be given to the plaintiff after evicting the defendant therefrom. The other release of the cost of the suit. This and that.
There was an issue of point of limitation and adverse possession.
There was an issue on that.
And what was the decision of the trial court on that?
Trial court held that I was in possession.
What was the finding on the issue of adverse possession? Where is the finding on the issue of adverse possession? Issue number 3. What is the finding with respect to issue number 3?
By the trial court?
Yes, because the appellate court says that it was not pressed. So I want to know.
It was not pressed.
Not pressed. Who did not press it?
It was not pressed by by the defendant.
Let us see where is the discussion with regard to issue number this issue.
तो उसको थोड़ा हमको और अच्छे से देखने होगा.
तो देखिए आइए 2:15 बजे देखकर.
आज मत कीजिए, आज थोड़ा हमारा चेस्ट में पेन हो रहा है.
तो आपको शुरू ही नहीं करना था ना, अननेसेसरी
हम बोले लास्ट टाइम आते वक्त थोड़ा पेन फील करने लगे, इसीलिए आज तो नहीं कर पाएंगे.
तो आप कब करेंगे बताइए?
कोई नहीं, आज छोड़ के
कल कर लीजिए.
ठीक रहे, अगर जिंदा रहे तो आएंगे.
तो हम भी जिंदा रहे तभी आएंगे. कोई भगवान ने कोई टाइम टेबल मरने का किसी का बनाया नहीं है, ना मेरा ना आपका.
ना थोड़ा ट्रबल ज्यादा हो रहा है.
इफ यू वांट
और
टू
गाड़ी
टेक
में
रेस्ट,
दौड़ के आने पड़ता है ना, और ज्यादा बढ़ जाता है.
दौड़ के नहीं आने का काम है सर, आप ऑनलाइन भी कर सकते हैं. कोई ज़रूरत ही नहीं है कोर्ट आने का. बहुत अच्छा ऑनलाइन प्रोसीडिंग होता है. यू डोंट नीड टू कम एट ऑल. यू बेस्ट बी कंफर्टेबल एंड टेक केयर ऑफ योर हेल्थ. दैट इज द मोस्ट इम्पॉर्टेंट थिंग. आप रहेंगे तभी केस रहेगा, नहीं तो क्या ही रहेगा. इसीलिए ऐसा दौड़ धूप करने का काम नहीं है सर. यू टेक केयर ऑफ योर हेल्थ. यू कैन ज्वाइन ऑनलाइन. यू जस्ट गो थ्रू इट. दोनों जजमेंट को इत्मीनान से देख लीजिए. ऐसा लग रहा है कि पूरा जजमेंट नहीं पढ़ा हुआ है. आप एक बार देख लीजिए इसको. ऑनलाइन करना चाहते हैं ऑनलाइन कर लीजिए, कोई दिक्कत नहीं. आपके लिए कोई टाइम फिक्स करना है तो हम टाइम फिक्स करेंगे. बताइए कल 2:15 बजे करेंगे.
तो कल करेंगे.
The arguments of the learned counsel for the
पास इसको मैंने पासवर्ड पढ़ दीजिएगा.
बिना ऑर्डर दिखाए लिखाए डिक्टेशन ऐसा नहीं होता. Essay number 500 of 2018. The learned senior counsel for the appellant, on account of his personal difficulty, is unable to conclude the argument today. He prays that the matter be posted tomorrow. कल कितना बजे? 2:15 बजे.
हाँ, 2:15 बजे का.
Post this
कल
matter. हाँ, 2:15 बजे
कल के तो
कल के. भालू दादा. ठीक है.
2:15 बजे आ जाएंगे कल.
आपको दिक्कत हो ऑनलाइन ज्वाइन कर लीजिए, कोई दिक्कत नहीं.
आ जाएंगे.
Item 13, second appeal 398 of 2019.
Yes, appellant.
Secret is out of station, madam, so I'm praying for custody on behalf of Miss Sophie.
Who is your senior?
Miss Sophie, madam.
Sorry?
Miss Sophie, madam.
Sophie. When is she coming?
Madam's next.
Okay, you read it. Let us see what is the matter about. You have read it?
My lords, I have gone through the case, my lords.
Why?
My lords, I just got the file. My lords, I'm not well versed with the facts of the case. My lords.
Then don't waste our time. You are happy with that? Seems to be very happy. टाइम मिल गया, बहुत अच्छा काम.
That much instructions was in mind, that is.
Next day you argue and let her be there. Okay.
That's nice.
नाम बताइए. Your name? Sorry.
NITI, my lord, Niti.
MS Niti. Niti submits that the matter is to be argued by MS Sudhi, who is out of station. She has not come to the court.
No, my lord, not today. She will come from tomorrow.
Then we'll post it tomorrow. Okay. She submits that the matter will post it tomorrow. Post tomorrow.
Item 14, second appeal 400 of 2019.
This appeal in judgment of reversal. The defendant is the appellant within. Originally, the suit was filed for partition of the suit property. And on someone when the defendant not appears, he filed one written statement stating that some of the property has already been gifted to them by virtue of registered deed of gift, and some parties are not there in the suit of partition. Then the plaint was amended, parties were made, and another declaration was also sought for declaration that the deed of gift is null and void illegal. Trial court decided all the issues, my lord, and it is decided in favor of the defendant holding issue number 3, 5, 9 and 11. The issues are there at page 73. Internal page.
Issue number. These are suit barred by limitation, estoppel, acquiescence. So these are the issues only.
Issue 3, 5, 9. Issue 3 is the suit barred by limitation, because the suit for declaration that the sale deed is illegal, null, void, and the date of gift deed was
1985.
1985.
Who was found in possession of the property?
The defendant. Then issue number 11 was as to whether the deed of gift number such and such dated 22/2/1985 is null and void, illegal, ineffective, conferring no right title to the donee, nor acted upon and not binding on the plaintiff. All these issues were taken up at page number 19 of the trial court judgment. Running page is page 81.
Yes.
Page 81. These, I may be allowed to say.
Page number 19.
Page 19 of the trial court's judgment. It is running page 81.
Issue number, yes.
Paragraph 25.
Yes.
These issues are substantial issue in view of the plaintiff's claim of relief that deed of gift number 6154 dated 22nd of February 1985 is null and void, illegal, ineffective, conferring no right title to the donee nor acted upon and not binding on the plaintiff, and rival claims of the defendant number 1 and his wife, defendant number 12, Somari Devi, that in the garb of partition suit, plaintiff want to get the land recovered from the defendant number 1 as such liable to pay a clerk court fee. The defendant have also taken the plea that this relief of the plaintiff is barred by law of limitation as the validity of document has been challenged after about 25 years of its execution. It is important to mention that the contestant defendant number 1 appeared and filed his written statement wherein he disclosed that after death of Moti Saw, his widow Musammat Mohini along with her daughter Fagmi
had executed a registered deed of gift, being gift deed number 6154 dated 22 to 1985 in favor of Srimati Somari Devi, who, wife of Mukhlal Saw, and also put the downing information over the gifted property, and so the story propounded by the plaintiffs about the land having been given on advertise to Leela Saw and Mukhlal Saw is nothing but a bundle of falsehood. After the filing of written statement by the defendant number 1, the plaintiff amended their claim and incorporated para 14A, in which the plaintiff have averred that through the disclosure made in para 7 of the written statement, the plaintiff have come to know about the gift deed number such and such dated 22 to 1985 in the name of Somari Devi, wife of Mukhlal Saw, and thereafter the plaintiff 1 and 2 asked Phaguni Devi, wife of Nanu Saw and daughter of late Moti Saw and Musmat Phaguni, about such gift deed, at which Phaguni Devi showed her ignorance and stated that gift deed was a false fabricated document obtained by playing fraud, and she had no knowledge about the existence of the document, nor she ever executed the said document. Admittedly, the gift deed executed by Musmat Moni and her daughter Phaguni Devi is a registered document. Original gift deed number 6154 dated 22 to 85 has been proved and exhibited by defendant as Exhibit A, which, with respect to a registered document, the Honorable Apex Court in the case of Tenancy vs. Tribal 2006 5 SCC 353 has held there is a presumption that the registered document is validly executed. A registered document, therefore, prima facie would be valid in law. The onus of proof thus would be on a person who leaves evidence to rebut the presumption. It will be only avoidable at the instance of a student on the ground of either fraud, misrepresentation, or coercion. In view of above stated principles, when I examine material and evidences on record, I find that admittedly during the lifetime of Musmat Muni did not take any steps for cancelling the gift deed on above stated ground. Plaintiff number 3, Phaguni had challenged the deed, but for avoiding the said gift deed, the plaintiff is required to prove the fact of fraud or misrepresentation or illegality thereof. However, on the perusal of evidence of PW4, Phaguni Devi, wife of Nanu Saw, I find that in para 11 of the examination in chief, she has thoroughly, she has rightly or something outrightly denied having executed any such gift deed in favor of Somri, and has stated that if any such gift deed is brought on behalf of Mukhlal Saw or Somri Devi, it may be treated as a result of fraud having been committed upon her and her mother. But this bare assertion of fraud committed upon her without any other cogent and reliable evidence of fraud or undue influence cannot rebut the presumption attached to the registered document.
What is the substantial question of law have you framed?
So, substantial question of law is that I have framed the question number 1 at page 9 of the brief, whether the learned appellate court has committed a serious error of record by holding the deed of gift exhibited does not fulfill the basic requirement of attestation as provided under section 123 of the Transfer of Property Act in view of section 68 of Indian Evidence Act. What happened in this case? The trial court has dismissed the suit. Then, so far this gift deed is concerned, dismissed. Then the plaintiff went in appeal. Lower appellate court, the learned lower appellate court, has again taken the issue of this gift deed, and then the learned lower appellate court has used to hold that requirement of section 123 of Transfer of Property Act was not fulfilled. Therefore, the deed of gift is void. So point of determination is at page 33.
Just a minute.
Gift is defined in section 122 of the Transfer of Property Act. Then
Transfer may be either by registered instrument or by delivery of possession.
Yeah. So transfer is admittedly in this case by registered instrument.
That's right.
It is exhibit A,
So
which is the original.
That's right. Gift deed was disbelieved by the trial court.
No,
No, okay. The appellate court has disbelieved that.
the appellate court has questioned the authenticity of the gift deed on
That's
the
right.
basis of that there is.
And the appellate court has also not discussed the findings of the learned trial court.
Money.
Which is that question of law, your friend? Roman 6.
In Roman 5, Roman 6. Don't know whether the finding of the learned court of appeal below are visited due to not meeting the reasoning of the trial court while upsetting the judgment on absolutely irrelevant consideration of the materials on record.
So 1, 5 and 6 should be sufficient?
Yes. And 1.2 also
1,
4.
5 and 6.
1, 4, 5 and 6. 4 is limitation. Limitation point is also there.
Okay.
Because their limitation.
Limitation के लिए कोई specific pleading का तो जरूरत नहीं होता है. It is for the court to see the limitation.
Yes. So limited for
You are saying that there is no plea.
limitation. We have taken the point of limitation also that it is, if any document is to be challenged, it is to be challenged within 3 years of the execution of the document.
What is the date of knowledge?
A date of knowledge.
They amended the plaint after they came to know through the written statement.
Yes, but my case is that it.
We will admit it only
yes.
on 1, 5 and 6.
Okay.
Second appeal number 400 of 2019 heard the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant submits that the learned appellate court has reversed the judgment and decree passed by the learned trial court. He has also submitted that the gift deed was a registered document and under such circumstances the requirement of attestation etc. as required under section 123 of Transfer of Property Act was not attracted.
No, attracted.
No.
But has been fulfilled.
Was attracted and in view of section 68 of the Indian Penal Act. He has also submitted that the learned appellate court has not met with the reasoning of the learned trial court while upsetting the judgment, and accordingly the provision of Order 41, Rule 31 of CPC has also not been followed. Considering the submissions and having gone through the impugned judgments, this appeal will be heard on the following substantial questions of law. 1, 5 and 6. Let notice be issued to the Respondent number?
All the respondents, there are 28 respondents. Therefore, I pray that the notices be ordered to be issued under the ordinary process.
Let notice be issued to the respondents for which requisites be filed under ordinary process by next Friday. इसमें क्या substitution वगैरह भी हो चुका है?
नहीं,
इससे लिखा है
पे यानी नंबरिंग गलत हो गया।
इतना इसमें corrections हैं?
वो करेक्शन हो गया ना, ट्रायल कोर्ट के जजमेंट को देख के टाइप कर दिया 17 ABC। तो यहाँ तो हाई कोर्ट में फाइल करेंगे तो सीरिएटम होगा 1 to 3। तो फिर हम ये स्टैम्प रिपोर्ट ऑब्जेक्शन था।
नहीं, ये dead and substituted अपीलांस, कई सारे अपीलांस dead and substituted हैं।
Appellants।
ये 2019 से ऐसे ही पड़ा हुआ है केस। You did not argue this matter since 2019.
There are matter also pending since
Sorry?
15, 16।
आपका कोई केस है? अभी दीजिए इसलिए। नहीं, कोई excuse है? And you have been taking time और आपको cost भी लगाया हुआ है।
लग गया था कुछ कारण होगा।
वही तो, ये खाली अपने कोर्ट को मत दोष दीजिए।
नहीं, कभी नहीं।
थोड़ा अपना
I
भी।
never blame।
2019 से केस is pending.
Respondent 10, but there was also substitute।
ठीक, ऑर्डनरी प्रोसेस से नोटिस बाय नेक्स्ट वीक फाइल करें। डिफॉल्ट मत करिए
जी।
प्रेम्पटी ऑर्डर कर दीजिए। लेट दिस ऑर्डर बी communicated, let the records be called for from the concerned court, let this order be communicated to us. Post on 25th March awaiting service. अभी तो रेस्पोंडेंट भी कितने सब जिंदा है कि क्या है अभी तो पता चलेगा।
एक आदेश हुआ तो सब्स्टिट्यूट होगा।
रेस्पोंडेंट कैसे अभी सब्स्टिट्यूट हुआ होगा?
हाँ,
नोटिस में रेस्पोंडेंट भी सब्स्टिट्यूट हो गया बिना नोटिस के किसी को।
अगर हमारा स्टेटमेंट था तो दिन टाइम है ना,
ठीक।
रिक्विजिट्स के लिए 24 तारीख तक का है या 31 तारीख तक?
नहीं, 31 तारीख तक है। 24 मार्च को अवेटिंग सर्विस स्टार्ट।
Item 15, second appeal 134 of 2020.
Defendant's appeal. Suit for eviction was on the ground of default was decreed and affirmed by the first appellate court. Very strange case.
You are the tenant?
I am a tenant. Admitted case, I am a tenant. Case of the plaintiff is that from March 2004 has defaulted in payment of rent.
March 2004.
And as per the case of the defendant merits, initially I was inducted as a tenant in respect of only 1 room. Thereafter, since my family, my family members grew merits where I was required more space, so plaintiff allowed me to construct a room, and she would, it was agreed that she would adjust the rent from the cost that I will repair. But here is a case where none of the parties, neither the plaintiff nor the defendant, adduced any documentary evidence. So what is important is the that's oral evidence. Here, the plaintiff was cross-examined. There was only one witness on behalf of her, she herself, and she was cross-examined. At para 55 of her cross-examination, she says it has been recorded that Vinod Saw को भाड़ा कर मेरे साथ कभी झगड़ा नहीं किया. Vinod Sahu is the original defendant. During pendency of the suit, he died. He was since been substituted by the present applicant. विनोद साव का बाल बच्चा लोग झगड़ा करता है, धमकी देता है, इसलिए मैंने केस किया. This is because this is a case where there is no documentary evidence. Neither parties have produced any evidence. So what is relevant is the oral evidence. And this has not been recorded anywhere, either by the trial court or the appellate court. I am reading from certified copy of the report.
What was the finding with regard to issue number 3?
By the trial court?
Yeah, by the trial court. Trial court framed issue number 3 on default.
Yes.
Yes. What is the finding?
Finding is that I have defaulted in payment of rent. Both the courts have gone into the fact that since the case of the defendant is that they had constructed the room by spending around 40,000 rupees, and that was to be adjusted, but no documentary evidence has been laid.
Where is the finding regarding issue number 3?
Yes, internal page 8. First paragraph, sir, in this regard, also DW1 though claimed in para 25 of the Procedural that they are regularly paying rent and payment of rent has never been stopped, and that earlier Malti Banerjee was issuing rent receipt, but after filing the case, receipt is not issued.
Essay number 134 of 2020. Heard the learned counsel appearing on behalf of the applicant. The learned counsel for the applicant has submitted that both the courts have decided the case against the appellant, who was the tenant, who was admittedly a tenant in the premises. Both the courts have held that the appellant was a tenant and a defaulter with respect to payment of rent from March 2004. The default was from March 2004. The learned counsel submits that that there was no documentary evidence adduced by either parties, and the plaintiff landlord had deposed in paragraph 55 that there was no dispute with respect to the original tenant, namely Vinod Sahu, but thereafter his heirs became the tenant over the property, and they used to fight with her. The learned counsel has also submitted that it was a case of the defendant that they were tenant in the property and certain rooms were constructed in which they spent certain money which was to be adjusted. The learned counsel has submitted that the findings recorded by the learned courts with regard to default is perverse. After hearing the learned counsel for the appellant and upon going through the judgments, this court finds that the factum of tenancy as well as the factum of default has been arrived at after considering the materials on record. This court finds no illegality or perversity. This court finds that no substantial question of law, much less any substantial question of law is involved in this case, calling for any interference. Accordingly, the second appeal is here dismissed.
Item 16, second appeal 221 of 2020.
Yes.
So
will argue.
Mr. Singh Kumar Sahni.
क्या मैटर है?
The judgment of reversal it has been filed with petitioner.
Counsel for the petitioner prays the adjournment is tomorrow. Next. कल तैयार हो जाइएगा, वो नहीं आएंगे तो कर लीजिएगा, ठीक? पास ओवर नहीं, तैयार हो जाइएगा, कल पास ओवर नहीं, तैयार हो जाना है.
Item 17, second appeal 222 of 2020.
Yes.
Just hand over a brief submission with the factual aspects it may be required. It is a concurrent finding of facts against the plaintiff. This is the plaintiff's second appeal. The plaintiffs filed the partition suit seeking for a relief for a decree of partition to the extent of their half share jointly and 1/4 share individually. And accordingly, the consequence of relief.
What do you mean 1/4 share individually?
There were two plaintiffs, the son and the mother. And on the other hand, the defendants 1, 2, and 3 they were implemented. The common ancestor, his first wife died, and then he married with the plaintiff, the original plaintiff number 2 who died. And from the second marriage, the present appellant was born. And the D1 and D2 were born from the first wife. Well, those facts are not disputed. The question which we propose for consideration as a substantial question of law is that here the basic issue, since it is a partition suit, the main thing which is required to be seen is whether there is unity of title and possession. Now the learned courts below has come to a finding that there has been partition by meets and bound, and so there is no unity of title and possession, and accordingly the relief sought for has been denied. While coming to the said finding, the first argument which I would like to advance, while coming to the said finding, the learned courts below has committed an error of law by considering an unregistered family arrangement which even otherwise would not have been admissible in evidence in view of section 17(1)(b) to be read with section 49 of the Indian Registration Act, and also it would be against the provisions of section 35 of the Indian Stamp Act. But here the finding is for the reasons that I am a party to the said unregistered sale deed. Even on that ground, the unregistered family arrangement could not have been considered. There cannot be any estoppel against law, because that is settled principle of law which has been decided way back in the year 1966, then 76, the Kale case, which is time and again reiterated and considered. So that is the main question we propose. Though we have framed a number of substantial questions of law in the memo, but in this short.
Which judgment are you relying upon?
We are relying upon the judgment of the Honorable Apex Court, Kale versus Deputy Director of Consolidation, that is 1976. We have quoted it in our written submission also.
Give me the judgment. 1976.
Volume 3 SCC, page 119.
19.
Yeah.
Para number?
10 subpara 4, 10.4.
10.4.
Yes. I have just quoted it in my written
No,
submission.
as a quotation, Senor. Where is the judgment?
The judgment it has been.
What other judgment are you relying upon?
Following the other judgments which has followed this proposition.
Basically, this is the proposal.
This is the main point, and then the other ancillary points are there, which are there were three schedules. B is the property which, according to the defendants, partitioned by this unregistered family arrangement. C is the property which was purchased in the name of the defendant number 1 and 2 when they were minor, when they were having no income. It is our specific pleading that it was purchased by the common ancestor, our father, in their name from the joint family property. Now,
fell in whose share as per the unregistered partition?
it is not mentioned anything. There is no mention of that Schedule C or Schedule D in the unregistered partition deed. Schedule C.
Simply it has been stated that there is no unity of title and possession.
Yes.
Where is the finding of the learned trial court?
May I refer to the finding of the learned trial court?
Yes, certainly.
That is running page 42, internal page 21.
And this judgment, I need that judgment also.
Yes.
Issue number 4, 5 and 6?
6. These are the main issues. The issues 4, 5, 6 are 4 was with regard to unity of title and possession, and then 5th was whether I am entitled or for any other claim. The issues that is at page 37.
Read that.
Issue number 4. Whether there is unity of title and possession between the parties with respect to the suit.
You read this page number 21.
Yes. Page 21. Issue number 4, 5, 6. The
Yes.
findings.
Yes.
I am just reading from 11 this sub-para issue number. So far as these issues is concerned, on this issue it is specific case of the plaintiff that whether there is unity of title and possession between the parties with respect to the suit property. In this regard, it is true that the two brothers have equal half share in the properties left by Babu Bhubaneswar Trigunite. But before his death, said Babu Sarat Chandra Trigunite took necessary permission. Here again it is a erroneous recording. Took necessary
Erroneous recording means?
No, because said Babu Sarat Chandra Trigunite, it should be said Babu Bhubaneswar Trigunite. Because Babu Bhubaneswar Trigunite had two sons, Sarat Chandra and Kalipada.
Okay.
So here, by saying said, it should have been Bhubaneswar Trigunite. Took necessary permission from the court of Subject Purulia 1959. This is not on record. Permission to make a gift of his half share to his two nephews, the D1, D2, because he was issued out of his own free will, and he was permitted by the learned subordinate judge to make such gift. And since often that Babu Kalapada Trigunite, our ancestor, received the amount of half share of the joint properties, and the remaining half share exclusively belonged to the defendant number 1 and 2. This gift is concerned, this is not consented gift, it was a gift of a joint property which is admitted, it is undisputed. So there is a, and he was permitted, and he was permitted by the learned subordinate judge to make such gift, and since often
No,
that.
how do you say it's a gift of joint property?
Yes, because it is
the person who was the owner of the property is gifting it.
No, Babu Sarat Chandra and Kalipada. It is admitted case, Babu Sarat Chandra and Kalipada, they inherited Babu Bhubaneswar Trigunite. And then Babu Sarat Chandra gifts the property. While
No, Babu Bhubaneswar gift the property.
No, Babu Bhubaneswar was the common ancestor.
Yes, he gifted the property.
No, it was gifted by Sarat Chandra.
You said that said is an error.
Before, no, this is correct. This line is correct.
आपको खुद ही नहीं
No,
पता।
this line is correct. I should correct it.
Any word को ऐसे error बोल देते हैं।
नहीं,
उसके
नहीं,
बाद
this-
my mind moves.
No, this line is correct. Sarat Chandra 59. I was referring to 1919 deed by which Bhubaneswar purchased the property, acquired the property. I was meaning that 19, but it is 1959. Sarat Chandra and Kalipada. It is admitted case. I can
See, the common ancestor was
Kalipada.
Kalipada.
Yes.
Two sons.
Three sons.
Three sons. नाम बताइए.
Basukinath,
Basukinath.
the present appellant, and then Sunil Trigunite and Anil Trigunite.
Sunil
and Anil.
Anil.
Yes.
So present appellant is Basuki.
Yes. Basuki was born out of the wedlock with
Just
the.
a moment.
With,
He is the present appellant and also the plaintiff.
yes.
Okay. So permission was granted.
Permission was granted. That permission is not on record. Even otherwise, in state of jointness, gifting a property without consent, that itself makes the gift deed nullest in the IFT. Now, makes a gift since often Babu received the amount of half share. This shows that there was, and this is admitted also in written statement. This permission was necessary because the receiver was appointed by the Court of Subordinate Judge Purlia in Title Suit 109 of 1906 as because the district headquarters of the Manhum district was at Purlia, and the necessary permission was accorded on 21/8/1959, and subsequently the deed of gift has been executed on 19/9/59, in which the different number 1 and 2 are the donees. The said deed of gift, the shares of said Sarat Chandra Trigunite has been described according to his share belonging to the entire properties of the Trigunite brothers estate, which was under the control supervision of the receiver, duly appointed by the Court of Subordinate Judge Purlia, in which Babu Bhubaneswar Trigunite had 1/3 share. But his residential house premises situated at Mauja Angarpatra and the property situated at Panchgadi over plot 836 and 837 under Khatian number 112 within Mauja Salanpur was taken permanent settlement by him by registered deed of settlement 27/10/99. I wish with this in the first paragraph. From the then Raja Sakti Narayan Singh 1900, son of so and so, as admitted by the plaintiff in para 2. Thus, said Sarat Chandra Trigunite made a gift in respect of his 1/4 share in favor of his two nephews, the defendant number 1 and 2, prior to his death, and 1/4 share remained with him, which devolved upon his younger brother Kalipada Trigunite after the death of said Sarat Chandra Trigunite on 17/10/68. This also shows that it was state of jointness when the gift deed was executed, because his other halves devolved.
Gift deed was executed by whom?
By Sarat Chandra Trigunite
By Sarat. In favor of?
in favor of the different number 1 and 2, Anil and Sunil.
How is Kalipada related to Sarat?
Kalipada is brother, own full brother of Sarat. And there was no party.
Just a moment. Sarat gifted to Sunil and Anil.
Yes. Defendant 1 and 2.
During the lifetime of Kalipada.
Yes.
From where do you say this?
From there, here itself, this line I am again reading, the story. If leadership is at page 22, middle portion, after the overwriting of correction of plot number 837, thereafter 1, 2, 3, 4, 5 line. Thus said, leadership got it. Thus said Sarat Chandra made a gift in respect of his 1/4 share in favor of his two nephews, the defendant number 1, 2, 4 prior to his death, and 1/4 share remained with him, which devolved upon his younger brother Kalipada Trigunite after death of said Sarat Chandra Trigunite on 17/10/1968. This makes it clear, and it is also their admitted case that there was jointness, and therefore they refer to this 2001 unregistered settlement, family settlement.
Where is the discussion of 2001 unregistered family settlement? You see page number 24 in the title partition.
Yes.
There has been a
yes
amicable settlement in respect of
there,
property.
yes. There had been and has been an amicable settlement in respect of the Scheduled B property.
B before Bombay.
Yes, Schedule B. And accordingly, a deed of family arrangement has been made on 28th day of March 21, which has been duly signed by the plaintiff and the defendant number 1 and 2, and the plaintiff and the defendant number 3 are witnesses amongst others. I also find and hold that the parties of the suit are not a joint possession over the suit land, and there have been partition by meets and round in respect of the suit land in between the plaintiffs and defendants. So the plaintiffs are entitled to 1/3 share, are not entitled to 1/3 share in the suit lands. And
This,
then,
this partition was an admitted document or there was a dispute in connection?
no, this partition we are disputing, Schedule P. This was their case. When we filed the suit, this was their case. They relied upon this deed family arrangement to say that there has been partition. And therefore, we are saying that this unregistered document should not have been looked into.
Your signature has been exhibited.
My signature has not been specifically exhibited, but I have not disputed my signature on that document. Even then, a court of law could not have considered a document for the purpose which has been created if the document is required to be registered under law, which 17(1) says it is compulsorily required to be registered, because it is creating, assigning a right. It is not a memorandum.
This deed of partition is an admitted document.
Yes, sign is there, but on the proposition of law,
With judgment.
yes. Para 10 on the left hand side. Para 10 in other words, have let's got it.
Yes.
In other words, to put the binding effect on the essentials of a family settlement in a concretized form, the matter may be reduced into the form of following propositions. Number 1, the family settlement must be a bona fide one so as to resolve family disputes and rival claims by a fair and equitable division or allotment of properties between the various members of the family. The said settlement must be voluntary and should not be induced by fraud, coercion or undue influence. Number 3, the family arrangement may be even oral, in which case no registration is necessary. Then 4, it is well settled that registration would be necessary only if the terms of the family arrangement are reduced into writing. This is important. Here also a distinction should be made between a document containing the terms and recitals of the family arrangement made under the document and a mere memorandum prepared after the family arrangement had already been made, either for the purpose of record or for information of the court for making necessary mutation. In such a case, the memorandum itself does not create or extinguish any right in immovable properties and therefore does not fall within the mischief of section 70, subsection 2 of the Registration Act, and is therefore not compulsory registrable, which is not in the present case. Then 5, the members who may be parties to my family must have some antecedent
So
title.
you said this is hit by 10.4.
Yes, so requirement of 17(2) is that it should be registered, because it is not a mere memorandum, it is creating a right, it is assigning an interest in the immovable property.
You have got a copy of this deed?
Yes.
Show me the family settlement.
It is marked as exhibit A.
heard the learned counsel appearing on behalf of the applicant. The learned counsel for the appellant submits that a partition suit was filed, but the same was refused to be decreed on the ground that there was no unity of title and possession. क्यों आप बीच में नहीं आप ऐसे सुनते नहीं?
I'm sorry.
The learned counsel submits that the partition suit was not decreed on the ground that there was no unity of title and possession with respect to the suit properties. पूरा ही property था?
हाँ.
He submits that reliance has been placed on an unregistered family settlement dated 21/3/2001.
28/3/2001. 28 March 2001.
आपका इसमें तो डीड का डेट दिया हुआ है 21/3.
28/3.
14 पेज 14 इंटर क्रिमिनल अपील का पेज नंबर पेज नंबर 14. The deed settlement deed is 21/3.
सिविल अपील में लिखा हुआ.
हाँ.
21/3.
कहीं 21/3 है, कहीं 21/2 है.
28 ही एक्चुअली है जो डॉक्यूमेंट एक्ट को दिया है. Exhibit number. If exhibit number is mentioned, so that will clear in doubt.
Family settlement dated 28/3/2001 within bracket exhibit
B. We forgot it.
The learned counsel submits that the said document itself created partition and therefore the same was required to be compulsorily registered. He has relied upon the judgment passed by the Honorable Supreme Court in the case reported in 1976 SCC 119 and has submitted that even if the document was an admitted document, the same could not have been relied upon to say that the partition had taken place. He has referred to section 17 dealt with section 49 of the Registration Act 1904. And has proposed the following substantial questions of law. ये आपके written notes में 2 question of
जी.
Considering the submissions, this appeal will be heard on the aforesaid substantial questions of law. Issue notice to the respondent number. How many respondents are there?
There are other the purchasers will be party. All notice will go because they are party. All the respondents.
कहाँ है respondent?
Page number 2 of the memo. Serial number 1, 2, 3 are the defendants and their successor in interest of one of the defendant who died. And 4 to 14 are those who has been sold
To
the
all
land.
the respondents under ordinary process for which requisites be filed by next Friday. That the records be called for from the concerned court. Pose this case on 25th of March in the supplementary cause list. इस judgment का copy रख देंगे इसमें.
Yes.
ये बात.
Oh, pleasure.
Item 18, second appeal 253 of 2020.
Present appellants were the defendant in the suit for partition, my lord. There is a concurrent finding of both the courts. My lord, the main point on which during the appellate stage, my lord, we have filed an application under Order 41, Rule Tab 27 for adducing additional evidence with regard to death of Nathu, my lord.
Order
Nathu,
41,
Rule 27. Additional evidence at appellate stage, my lord.
That has not been considered.
That has not been considered, my lord. And the Honorable Supreme Court says, my lord, in a recent judgment even earlier, there are three limbs of Order 41 through 27. The main third limb, that whether that evidence is required to give a proper judgment.
Who was this Nathu Ram?
Nathu was these appellants were the descendants of Nathu, my lord. And the dispute, if lords, ladies may kindly come to the appellate court judgment, my lord, for a while. My lord, it will be apparent that how this it is important. My lord. Para 14, my lord.
The appellate court is
Appellate court judgment, my lord.
para number?
14, my lord. Internal page 15, running page 37.
Para 14. Yes.
Now
Has
the
not
main-
considered the additional evidence.
No, my lord. Because in that case, he has firstly rejected the additional evidence, my lord. We have preferred a CMP before this honorable court.
So it is not a matter that he has not considered.
Again, we filed an application because that CMP was dismissed because of non-filing of the requisites, my lord. Then the restoration was filed. It was not decided on merits, my lord, that CMP. Again, we filed a similar petition under Order 41, Rule 27. That kindly consider this. In spite of that, that has not been considered. And that was specific my substantial question of law, my lord. Because that was the main thing, who was the surviving last who has died, my lord. That was the dispute. It was the specific case and he has relied on the oral evidence but has not relied on the documentary evidence. And that is clear breach of section 91, 92 of the Evidence Act, my lord.
When did he die?
My lord, he died, my lord, in 1987, my lord, long back. And he was the last person, he was the last surviving. So, and this was the only dispute, that who has survived last. And that for that we have filed a cremation register, set, my lord, that when he has been cremated in the guard. And that register was what I want, with the appellant want to prove during the additional evidence, my lord. And that was that he got later on, my lord. For that reason, he has not been able to produce it during trial, my lord. And that discussion has been given. Even the Nathu Gorai was examined in GR case number 237 of 1987 on 17/4/1982, and that has also not been considered by the learned appellate court or by the trial court. And he has relied on the oral evidence, my lord. May I read the 4 paragraphs are, my lord?
You read para 17.
Para 17.
Because your case is resting on additional evidence.
Yes, ma'am. Para 17.
Yes.
In view of the provisions, it is apparent that the defendant's appellant, knowing very well that a dispute with regard to death of the aforesaid Kanai Gora and Nathu Gora is in the case, but had not filed the said documents before the learned lower court. Further, it appears that earlier the said petition of appellants under Order 41 Rule 27B CPC with regard to death of Kanai Gora has already been rejected by this court, against which the appellants have preferred a WPC number 2897 of 2016, which was dismissed for default by the Honorable High Court, and admittedly in restoration petition has been dismissed by the High Court. It appears that the present appeal has been filed after the appellants on 22/4/2015, but the petition under Order 41 Rule 27B with regard to the consideration of the death certificate of Nathu Gorai has been filed on 7/2/2022. It appears that the appellant has admitted that the said certificate was issued on 9/2/2062 and procured by the appellant in year 2016, but the said document has been filed by the applicant before the appellate court on 7 to 2022.
Yes, why should we take such document into evidence?
My lord,
It is not a case, right? You had this document but you never produced it. That petition was rejected, you challenged it, the writ petition was dismissed, the CMP was also dismissed.
sir, it was dismissed for
Maybe,
not on merits, my lord.
maybe, but the order by which it was rejected was certainly on merits.
No, we rejected, my lord. No,
Rejected
it was
means-
because requisites were not filed. That's for that reason it was.
No. In the High Court, it was rejected because the requisites were not filed. But the trial court or the appellate court, wherever that additional evidence was filed, they must have considered it.
My lord,
Passed an order on merit.
and this honourable court issued notice, my lord. If without
So-
satisfying, my lord, the High Court will not issue notice, my lord. My lord, main
वकील का गलती से ना लिटिगेंट को सफर करना ही पड़ता है, वो चाहे ना चाहे, right?
That's true, my lord. My lord,
That
now
is the
the Honourable
problem.
Supreme Court says that the main thing is that, my lord, that has to be considered.
That's right.
That the appellate court to take additional in exceptional circumstances where the additional evidence sought to be adduced removes the cloud of doubt over the case and the evidence has a direct and important bearing on the main issue in the suit, and interest of justice clearly renders it imperative that it be allowed to be permitted on record, such application may be allowed. The admissibility of the additional evidence does not depend upon the relevancy to the fact or issue on hand, or on the fact whether the appellant has an opportunity for adducing such evidence at the earlier stage or not, but depends upon whether or not the appellate court requires that evidence sought to be adduced to enable it to pronounce judgment or for any other substantial cause, my lord. The true test therefore is whether
Just give us 2 more dates. When was the suit decreed?
the suit was decreed, my lord.
Suit, what is the date of the suit? Number of suit?
The number of suit is, my lord, let us see, the title suit number 63 of 2003, my lord, which has been decided by the
Just a
learned
moment. 63 of
2003.
2003. Okay. Then it was decided on?
Decided on, my lord, 3rd March 2015.
3/2015, right? Then when was the appeal filed?
Appeal number is, my lord, civil appeal number 17 of 2015.
17 or 15. When did you file your application for additional evidence?
My lord, I first filed the application in 2020, my lord. And admitted,
When was it rejected?
my lord, it was rejected, my lord. In 2020, it was rejected, and thereafter we have referred a WPC. No, it was rejected on 2016, my lord. In 2016, and it was dismissed thereafter, my lord. WPC 2897 of 2016.
WPC number?
2897 of 2016. The second application was filed on 2020, my lord.
This was dismissed.
Yes, my lord.
Restoration also dismissed.
Yes, my lord. The restoration dismissed. Because at that time, this judgment of appellate court has already been pronounced, my lord.
We do not know what is the
And
date.
I'm saying
Anyways, thereafter you file a fresh application
fresh application, my lord.
on 2020.
Yes, my lord.
That was rejected by referring to the earlier order.
Yes, my lord. And this is my main substantial question of law, my lord, because
Which is that substantial
Yes,
question
ma'am.
of law you are doing?
D, my lord.
D.
D. Whether the learned appellate court ought to have admitted the additional evidence by which the present appellants were trying to show that Kanai Gora has died on 22/11/1978 by
So
producing.
this document to show that he died in the year 1978, you procured a document in 2016
Yes, my lord.
by showing that in the Shamshan Ghat
Register,
register,
that we
in
pro-
1978 that
we-
entry was made.
We procured it in 2017
So,
because with the
but
Kanai
that
Gora-
entry was made in 1978.
Yes, madam.
Who will prove that?
Madam, if they were summoned, my lord, the register, the persons would have come, my lord.
Who?
Who has prepared the register, my lord, or the register would have been produced before the court, my lord.
Continue, please. By producing the extract of register of burning heart,
Where Kanai Gorai was cremated and by not doing so, the learned appellate court has committed an illegality and not appreciated the law settled by the Honorable Supreme Court in plethora of decisions which clearly states that Clause B of Sub-Rule 1 of Order 41, Rule 27 is the prime consideration where the appellate court have to see whether the additional evidence is required to be admitted which will enable the court to pronounce the judgment or any other substantial cause, and since the main dispute was with regard to death of Kanai Gorai and Nathu Gorai, the said documentary evidence ought to be admitted by the appellate court at the stage of delivering judgment, rather only on that ground that earlier against the dismissal of the petition, the appellate court the appellate had preferred a application under 227 which was not dismissed on merit but on for default. And E also, my lord.
so you want to adduce evidence regarding death of two persons,
Yes, ma'am.
not one.
No, my lord.
Both of them.
Both of them. To show that Kanai Gora has died on 1974, their specific case was Kanai Gora was the last person who was the surviving, my lord. Our case is that Nathu Gorai was the first person who was the last who was the surviving, my lord. Further in the Kanai Gorai, it was not in our custody, my lord. Then we got the news that Kanai Gorai was the other side party, my lord. So we then rushed to the and tried to find out that document. And after getting that, the suit was already decided, my lord. So immediately the appeal was filed, and then thereafter this additional evidence petition was filed in 2016, which got dismissed, which ought not have been dismissed, my lord. The Honorable Supreme Court says, my lord, that it should not be dismissed. It should be kept on record, and at the time of delivering of the judgment, it should be seen whether it is required to give a proper judgment or not. That is the, and this is the recent judgment of the Honorable Supreme Court on that issue, my lord. And even, my lord, the documentary evidence has not been, because it has, if ladies may kindly see that it has been admitted, my lord, if ladies comes to page 17, my lord, or internal page 17 of this first appellate court judgment, my lord, wherein it has in the last exhibit B and E filed by on behalf of the defendant appellant reveals that Nathu Gorai was examined as a witness in GR case number 237 of 1980 on 17/4/1982, which reveals that he was alive in 1982. But the oral evidence is adduced on behalf of the plaintiff and defendant clearly reveals that Nathu Gorai died on and about 1982. So, my lord, whenever there is a dispute with regard to oral evidence and documentary evidence, so documentary evidence will prevail, my lord, according to section 91 and 92 of the Evidence Act, my lord.
Page 17.
Page 17, my lord.
There is no page 17 of
Of
the
the internal page 17 of the appellate court judgment, my lord. Paragraph 2, in the last portion, my lord, DW1 Anand Gorai was the son of, who is the appellant, my lord. In the last portion, my lord, 5 lines from the below, my lord.
I want to know from you, in your plaint, what was the date of death of these persons?
My lord, date of these persons.
What was your case in the plaint?
In my written statement.
Yes.
In my written
In
statement.
your written statement, what was your
my
case?
case on the written statement
When did he
is
die?
my case in the written statement that I was this Nathu Gorai has.
When did they die? What was your case in the written statement?
My case in the written statement, my lord, is that he died last, my lord.
When?
In 1987, my lord. 87, and that has
Where
not.
is it? Where is it?
My lord, I am saying.
And what is the finding regarding their death?
The trial court, my lord.
Yes, by the courts, because you are talking about the date of death. What was your case in the written statement? You see, you are claiming now that they died on 24/6/1986, and the other one he died on 22/11/1978.
Yes,
right?
ma'am. Yes.
Kanai Gorai died on 22/11/78,
And
and Nathu Gorai
yes,
on
ma'am.
24/4/1986. What
Yes,
was your case in the written statement?
In para 3, the defendant Anand Gorai, Barka Gorai, all sons of has appeared and filed their joint written statement alleging inter alia there is no cause of action for the suit as against the answering defendant, and they have never been approached for amicable partition, nor they have ever refused to do so. 7 except which has been specifically admitted in the written, the defendants hereby deny all allegations made in, but the plaintiff to stick prove there. So far it relates to house in question, these defendants submit that beside the ancestral house, the defendant themselves in the course of their separate living has also constructed some extra houses in their individual peaceful possession of the same, having their absolute right of ownership. It has been further pleaded that averment in para 4, 5, 8, 9 in the plaint substantially correct. The genealogy appended to the plate is separate sheet is averred. In para 7 of the plate is also admitted with the modification of the name of given Ananda Gorai, which has been wrongly been titled Arvind Gorai. The averments of the in para 11 are admitted to be correct, with an addition that Nathu Gorai, being the youngest son of Jitu Gorai, died at last amongst the brothers, son of Jitu Gorai. These defendants submit that they were all along willing and ready to an amicable partition by meets and bound. The plaintiff are entitled for 4/5 share in both the suit property A and B has been decided and confirmed in finality during the lifetime of the ancestor of the parties in
So there
question.
is no mention of the even
Specific
tentative
date,
date.
specific date.
Specific year is also not mentioned.
Yes, ma'am. That is not mentioned.
That is not mentioned.
My lord, subsequently, my lord, during evidence, my lord, we have produced it and we have produced the documentary evidence, my lord, that ought to be
Second appeal number 253 of 2020. Heard the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant submits that the present case is fit to be admitted on following substantial question of law. Para number page para Roman 9 ka small d and small e. The learned counsel submits that the entire case revolved around death of Kanhai Gorai and death of Nathu Gorai, who expired on 22/11/1978 and 24/4/1986 respectively, and you were the defendants. Defendants wanted to adduce evidence with regard to date of death by referring to the cremation and a register of cremation. He has submitted that the learned appellate at the appellate stage. He has submitted that the learned appellate court did not allow the additional evidence and the learned counsel has further relied upon the judgment passed by the Honorable Supreme Court reported in 2022 Live Law SC 268 and has referred to paragraph
4 and 5.
Paragraph 4 and 5 of the said judgment to submit that as an exception, Order 41, Rule 27 CPC enables the appellate court to take additional evidence in exceptional circumstances so that the court can arrive at the findings with respect to the dispute between the parties. During the course of argument, the learned counsel for the appellant has submitted that in the upon a query of this court has submitted that in the written statement no specific date of death of Kanhai Gorai and Nathu Gorai was mentioned, much less any year of date, much less the year of their death. it has been simply mentioned that at last they had died. The learned counsel submits that the additional evidence ought to have been admitted by the appellate court, and therefore this appeal is fit to be admitted on the approaches substantial questions of law. After hearing the learned counsel for the appellant and upon going through the judgments passed by the court, the only argument advanced on behalf of the appellant is in connection with the additional evidence which was adduced by the appellant before the appellate court under order 41, rule 27 within bracket B of CPC. The findings of the learned appellate court. This court finds from the perusal of the appellate court's judgment that an application for adducing additional evidence with regard to the learned counsel by the appellant has also submitted that the application was filed in the year 2016, but the same was rejected, which was subject matter of challenge in WPC number 2897 of 2016. However, the writ petition was dismissed for default, and ultimately another petition was filed on 7/2/2020. The appellate court has rejected the subsequent application also. उसके बाद लिखिएगा after hearing the learned counsel for the appellant and upon going through the judgment passed by the learned appellate court, this court finds that the application seeking to bring additional evidence on record was dismissed by the appellate court way back in 2016, which was subject matter of challenge in the writ petition, but the writ petition was ultimately dismissed for default. Thereafter, the appellant had filed another application for the same relief. The learned appellate court has considered this aspect of the matter and has also considered that the appellants had admitted that the certificate was issued on 9/2/2016 and had procured the same in 2016, but the same document was sought to be adduced before the court on 7/2/2020.
That is an error, my lord, because we have filed it in 2016 itself, my lord.
This court finds that during the course of hearing, the learned counsel for the appellant has also submitted that no specific date or year with regard to the death of Kanhai Gorai and Nathu Gorai was mentioned in the written statement. Considering the totality of facts and circumstances, this court finds that the learned appellate court has rightly rejected the application for adducing additional evidence this court is also of the view that once the application for additional evidence was rejected by the court and was subject matter of challenge in the writ petition, which was also dismissed, there was no occasion for the court to entertain second application for the same relief. The learned court has also recorded that, has given this finding. ये para number, page number 43 से यहाँ से इसको quote कर. This court is of the view that no substantial question of law is involved in the present case, which is hereby dismissed.
One judgment is also there of the Honorable Supreme Court, my lord. Where?
Whatever you have cited,
No,
I have heard
yes,
you.
my lord, where?
Order
Only-
होने के बाद
नहीं।
judgment cite मत करिए. चलिए next question.
Item 19, second appeal 62 of 2021.
Yes.
Yes, sir. Lordship, may I claim that it may be taken up by tomorrow because I went outside तो जिस तरीके से देखना चाहिए तो उस तरीके से नहीं देख पाया.
क्या मैटर है आपका?
इसमें जो suit petitioner where the appellant where the plaintiffs suit dismissed हुआ, thereafter preferred an appeal, that appeal was dismissed. The prayer was made for right title interest and confirmation of possession, your lordship, and subsequent prayer was that the defendants have no
Learned
concern
counsel
with
for the appellant seeks adjournment. Recently said the matter be posted to the post tomorrow. Next.
Item 20, second appeal 63 of 2021.
Yes, appellant.
Kind for this time, your because of mercy, the matter was settled outside the court, your lordship. So I find the compromise.
क्या मैटर है?
Matter, your lordship, plaintiff has claim on the basis of the Khatiyan, your lordship, and the defendant has claim on the auction sale, your lordship.
It has been settled outside the court. Should I
Lordship.
record your statement?
Lordship.
आप ले लिए हैं कुछ?
Lordship. दोनों
Yes.
में से compromise
कहाँ पे outside court कहाँ पे compromise?
Yesterday, your lordship.
कहाँ पे compromise हो गया outside court after the dismissal of the case?
It is as per the information of the defendant appellant.
कहाँ पे compromise हो गया?
पंचायत में हुआ लॉस.
After the dismissal of the cases, the case will be settled in panchayat.
As per the information लॉस.
पिछली बार आपको फाइन लगा था ना?
तो आप फाइन लगा थे लॉस.
कोई बात नहीं, आप लोग जॉइंटली फाइन दे दीजिए. अब तो जॉइंटली कॉम्प्रोमाइज कर लिए, है ना?
लॉस 2 वीक्स टाइम हम रिकॉर्ड कर लेते हैं.
कोई बात नहीं, फाइन तो एक बार 1000 रुपए लगा था, इस बार 10,000 लगा दीजिए. जो दोनों जने मिलके 5-5 हजार.
कंप्रोमाइज को हम ले आते हैं लॉस के रिकॉर्ड पर. जोड़ पास करना होगा लॉस. लेकिन ये कंप्रोमाइज जो हुआ इस पर इंफॉर्मेशन ऑफ द डिपेंडेंट अपीलेंट.
आप ऐसा करिए, आपको अपीलेंट ने फोन करके बताया है ना?
लॉस
टेक्स्ट में ले लीजिए कि कॉम्प्रोमाइज हो गया है. हम लिखाएंगे उसको, उसके बाद आपका सबमिशन वी विल सी ऑन द नेक्स्ट डेट. टेक्स्ट में ले लीजिए, व्हाट्सएप में टेक्स्ट ले लीजिए, चाहे कुछ भी ले लीजिए, उसके बाद सबमिशन करिए. चलिए बाहर जाके टेक्स्ट में लेकर आइए and you just tell us that you have received it on message that it has been compromised and a joint compromise petition is going to be filed.
जॉइंट कंप्रोमाइज का कॉपी भेजा है लॉस हम उसको रिकॉर्ड में जाएंगे.
आप जाके क्लियर, आपका सबमिशन जो है ना आपके क्लाइंट के इंस्ट्रक्शन से मिसमैच नहीं होना चाहिए.
एकदम लॉस.
आप अपना नहीं ऐसे नहीं करेंगे. आप उनसे मैसेज में ले लीजिए.
हम ले लेते हैं
मैसेज आप लेकर आइए ना, हम लिखाएंगे यही चीज जॉइंट कॉम्प्रोमाइज पिटीशन का काम है. आप मैसेज में लेके आइए. It should be on proper instructions, and I will record that you are saying that you have been specifically instructed that there is a joint compromise has already been arrived, and you are on the process of filing joint compromise petition. आप लेके आइए, टेक्स्ट में मैसेज लेके आइए. टाइम लेने के लिए कॉम्प्रोमाइज का कहानी मत सुनाइए हमको. आप टेक्स्ट लेके आइए, मैसेज में लेके आइए, हम तुरंत एडजस्ट कर देंगे बिना फाइन के. नहीं तो 10,000 रुपए फाइन. लेके आइए, जो टेक्स्ट करेंगे हमको बताइए. नेक्स्ट.
Item 22, second appeal 101 of 2021.
Yes.
One week time just to confirm on information.
What information?
Ladyship, there is a
Specific relief application. What information?
Lordship, in the judgment, it it is stated that the parties got partition in 1985, but in the cross, it is stated that parties have got partition in 1965.
So that's on merit. Why do you want time?
Lordship, as the parties got both parties are interrelated. Both are descendants of Lalman Daswami and.
So you argue on merits. Why do you need time?
That's because I'm not graduate. And
How long have you been practicing?
Lordship, since 1.5 years.
1.5. आपका दूसरी जगह तो काम नहीं होगा आज 1.5 साल का प्रैक्टिस से कम ही केस रहता हो पढ़ना शुरू करिए शाम को सुनेंगे आपसे टाइम नहीं देंगे नॉट टुडे नहीं होगा पढ़िए नहीं तो पूरा का पूरा पिटीशन जो है ना ऊपर से नीचे तक 100 पन्ना पढ़वाएंगे आपसे कोर्ट पढ़िए दोनों जजमेंट पढ़िए थोड़ा सा मेहनत करिए ठीक है ठीक से मेहनत करके बहस करेंगे तो हम आपको टाइम दे देंगे क्या फाइंडिंग है क्या इशू फ्रेम हुआ क्या रेस्पेक्टिव केस है एकदम यहाँ बैठ जाइए आराम से बैठ के पढ़िए
Item 23, second appeal 49 of 2023.
Yes. Who will argue?
Abhishek Kumar Dubey.
Aso.
Item 24, second appeal 120 of 2023.
If I need to take steps for substitution in this matter,
Who is this by?
which is the respondent number 114 if I'm not wrong. But if I've just been informed today itself in the morning, hence I'm saying only not today. I'll be taking the steps immediately.
Respondent number?
So 112.
There is a renumbering of respondents.
But if I verify it,
Give me the name.
Beni Nath Ram.
Beni Nath Ram.
Yes.
He is 112.
112. He has right. So I've just been informed today in the morning. So I'm only seeing not there. I'll take the steps immediately.
Okay, essay number 120 or 23. Also for the appellant submits that. Beni Nath Ram, within bracket respondent number 112, has expired. And he submits that he has received telephonic information about his death today itself. He submits that he shall. He prays for 1 week time?
Yes, sir.
Post on next Tuesday in the supplementary process for this.
So it can be Thursday. Only Thursday. Next Thursday. Obliged.
Passover case, item 4, second appeal 531 of 2017.
Yes.
In this case, we note some of the respondents, that is respondent number 20 and 75, have diagnosed and some notices have been returned due to insufficient address and.
This is for orders?
Yes, yes.
अच्छा कोई बात नहीं सब्सटैंशियल क्वेश्चन ऑफ लॉ पढ़ते हैं किनका डेथ हो गया
Respondent number 20, respondent.
It has been returned unserved.
Yes.
Saying that they have expired.
Yes.
75 and 20.
Your Lordship, only see 2017 matter, we are in 2024. 60 days delay, the second appeal was filed.
Or do the respondents number मर गए respondent number 15, 16, 25, 26, 36, 39, 40 to 42, 44, 76, 80, 88. सबका डेथ हो गया
I will file the substitution. I will take the fresh steps for other.
75. क्या हाल बना के रख दिए 2017 का केस सभी मर जाएंगे बचेगा कौन? How can you be so negligent about a case? How many years have elapsed? Tell us. कितना साल गिन के उंगली में गिन के?
The rustic villagers has approached.
Rustic villagers, you know, they have lost hope. पूछते भी नहीं होंगे फोन करके कि केस का क्या हो रहा है. नहीं पूछते होंगे ना.
वो आकर के बताया कि एक तो मर गया जिसके बारे में उसको मैं
17 से क्या बता रहे हैं? नहीं पूछेंगे. People are settling with their disputes. उसके साथ जीना सीख गए हैं, कोर्ट भूल गए हैं और वकील साहब को भी भूल गए.
इसमें सेटल नहीं हुआ है, वो कंटेस्ट कर रहे हैं.
क्या ही करेंगे?
फ्रेश स्टेप्स हम ले लेंगे.
फ्रेश स्टेप अवेट कर जाएगा ना तो हम रेस्टोर भी नहीं करेंगे.
अप्रॉक्स 100 रेस्पोंडेंट्स हैं.
तो क्या हो गया? फाइल लिए तो सोच समझ के लिए ना. हमको
ये जो एक्सपायर कर गए हैं आइए फाइल करके मैं सब्स्टिट्यूट करता हूं और बाकी जो फ्रेश स्टेप्स लेना है जो अनसर्व्ड है ड्यू टू इनसफिशिएंट एड्रेस और
न्यूज़पेपर पब्लिकेशन टाइम्स ऑफ इंडिया में कराएं. बेस्ट. ना भारत टाइम्स हिंदी एंड टाइम्स ऑफ इंडिया इंग्लिश. क्या
ये खूटी का है लोकल डेली.
Your Lordship may only see the order before the last order. It was by the bench has already passed an order where it has said that in this matter.
Now that chapter has closed and now thereafter the order has been passed on 29th July 2024.
कौन सा ऑर्डर?
I don't.
ऑर्डर बताइए. ये है
by Honorable Justice Gordon.
डिले कितना है? लिमिटेशन पर ही बोला.
Approximately 60 days.
53 days.
53 days.
मिस्टर राहुल, डेथ होने से दिक्कत है.
वो हम मान रहे हैं.
डेथ होने से बहुत दिक्कत है.
Otherwise, the
Otherwise, there was no problem.
matter against many of the respondent has already abated. They must have died 90
You
days.
see, the first noting which we have about the death is in the month of this is 9/5/24. तो अबेट तो हो गया आपका. अबेट हो गया ना. 9/5/24 को ऑफिस नोट है. कब का ऑफिस नोट है ये?
And we are in
10/6/24.
we are in January 2000.
कौन से डेट का? 21/25.
Then my only prayer would be that he must at least may not sleep over the matter. He must take immediate steps within a week or so.
Okay, learned counsel for the appellant, and you have for respondent number?
Respondent number 64.
And respondent number 64 are present. As per office note, respondent number 2, 3, 5, 8 to 10, 14, 47 to 49, 50 to 62 and 64 to 69 have been received by the family member, namely Sohad Khan. The learned counsel submits that the notice be accepted as valid. Notice upon the aforesaid respondents is accepted as valid. Respondent number 15, 16, 25, 26, 36, 39, 40 to 42, 44, 76, 80 and 88 and also 75 have expired. Counsel for the appellant seeks adjournment to take steps. Respondent number 17, 18 and 19 have been served by themselves or through close relative. The notice is accepted as validly served. Respondent number 27 has been served by his son, accepted as validly served. Respondent number 21 to 24, 32 and 17 not found. The learned counsel submits that we shall take appropriate steps in connection with the aforesaid respondent number 21 to 24, 32 and 70 under at their present and correct address. The requisites with respect to service of notice upon the aforesaid respondents 21 to 24, 32 and 70 at their present and correct address be filed within 15 days peremptory.
Notes the appellants may be permitted to use the returned memo of petitions.
नहीं अभी तो यहाँ पे तो कुछ है नहीं हम
That has returned, that is on record.
we do not know not found करके यहाँ पर तो है नहीं अब हम नहीं जानते आप
That
fresh
is
step ले
वापस आ रहा है.
Respondent number 20 and 38 has been received by respondent number 46. ये कौन है 46? अच्छा ये आया हुआ.
So appellants may be permitted to use this.
I'll permit you. Respondent number 46. Who is respondent number 46? Maimun Khatun. कुछ पता नहीं चल रहा है कोई इसका रिलेशन नहीं पता चल रहा.
My trial will be against all those persons paper publication they could have done.
वो अपना जो मर्जी करे
How many
substituted
times they
substituted service of notice तो फाइल करना पड़ेगा ना that they are faceless they are not
ऐसे ही
able
चलते रहेगा यही प्रॉब्लम है नहीं तो अदरवाइज हम
सारे में preemptory order कर अपने सब DFD हो जाए.
3 weeks time कर दीजिए.
Respondent number 6, 46 has been served personally, accepted as valid. Respondent number 43 and 45 served through nephew, accepted as valid. Respondent number 35 and 36 served personally, accepted as valid. Respondent number 30 and 31 by nephew, accepted as valid. Respondent number 28, 29, 33 and 34 SR not received. The appellant to take fresh steps for service of notice on these respondents.
20 died.
Office note में तो नहीं.
My lord, I am appearing on behalf of the respondent number 20. वकालत नामा has been received. उनका लीगल हेयर में जो आए थे डेथ सर्टिफिकेट दिए हैं डेथ करके हम
Learned counsel for the appellant has submitted that respondent number 20 has also expired. इसमें 20 में ऑफिस नोट नहीं है. ठीक है मिस्टर नाम बताइए.
मनोज कुमार राम.
Mr. Manoj Kumar Ram, advocate, submits that he has received instructions on behalf of legal heirs of respondent number 20.
Yes.
And he shall furnish the details of the legal heirs of respondent number 20 to the learned counsel for the appellant within a period of 1 week. दे देंगे ना आप उनको?
Yes.
38 को फ्रेश नोटिस करना है, ठीक है?
At least 4 weeks time may be given.
आपको सब टाइम देंगे, 4 साल दे देते हैं टाइम।
Only 4
जो
weeks.
भी बचा कुछ है वो भी सब खत्म हो
Only
जाएगा।
4 weeks I will complete all these things.
4 साल हो गया, इतना साल, अभी 4 साल और दे देते हैं। देखिए 38 के लिए फ्रेश नोटिस करना है, फ्रेश स्टेप्स फॉर सर्विस ऑफ नोटिस अपॉन रिस्पॉन्ड नंबर 38। 27 बेटा ने रिसीव कर लिया है, 30, 31 रिसीव बाय नेफ्यू, हाँ 71 to 75, 78, 79, 81 to 87, 89 to 94 received by family members accepted as valid. Respondent number 77 का fresh notice कराइए, ठीक है? He has to take steps of fresh service of notice upon respondent number 77. Respondent number 146. अच्छा, ठीक है. That's all. Needful be done within a period of 4 weeks from today. सब सारे orders रहेगा predatory आपका, ठीक है? ये तो हमको नहीं लगता है कि मेरे लाइफ टाइम में खत्म होगा ये केस. I can see this.
And the appellants may
मेरे लाइफ टाइम में नहीं खत्म होगा.
appellants may be permitted to use the
The
return.
appellants are the counsel for the appellant is permitted to use the returned copy of the notices. The envelope be kept intact. Envelope मत दे दीजिएगा, ठीक है? खाली नोटिस का कॉपी देंगे. Post this case on 30th April, awaiting service report.
Pass over case item 5, second appeal 2 of 2018.
Was admitted on 31/7. After that, notices were issued to respondent number 7 to 18 महीना. इसमें respondent number 7 का death हो गया मेरा. As per office.
कब?
Office notes.
Office note dated?
Legal and sister already on record, my lord.
Petition तो फाइल करना पड़ेगा ना?
हाँ, petition में petition फाइल करें.
Learned counsel for the appellant submits that respondent number 7 has expired as per office note. बाकी का?
Notice sir.
The learned counsel for the appellant has also submitted that so far as other respondents are concerned, either they have been personally served or they have been served through close relative. Najma Khatun, respondent number 85. Considering the submissions, the notice upon the concerned respondents who have been served personally or through their close relatives are accepted as valid. चलिए कब रख दें? नहीं? कब रख दें?
After 2 weeks में इसमें हम delegation के लिए application फाइल करते हैं.
post on 21st February for orders. आप चेक कर लीजिए, बाकी सब ऐसा तो नहीं कि कोई छूट गया है, because rest is accepted as valid, no? You just check it. कल से जितना आपका ये ऑर्डर्स का है ना केसेस, जो इनफ्रक्चुअस केसेस टाइप का दिख रहा, जिसमें सालों से कोई स्टेप नहीं हो रहा है, 4 बजे टेकअप करें टुमारो। कल से नोटिस ही रहेगा 4 बजे। हम पूरा दिन ये आपका ये मिसलीनियस ये सब इनफ्रक्चुअस केसेस में अपना दिमाग नहीं लगा सकते हैं ना।
ठीक।
There's so many cases, 17, 16, 15.
अपील्स में क्या होगा, सेकंड अपील में जैसे पार्टीज बहुत रहते हैं सिविल
नहीं,
इसका
you
डेथ
see,
हो गया, नहीं हो गया।
no, we appreciate that. But 2017 में नोटिस 2025 में होगा तो मर ही जाएगा ना कोई ना कोई। The cases become infructuous.
और जैसे रेगुलर कम्युनिकेशन नहीं होता है, फोन नंबर्स बदल गया, जो फोन नंबर लिखा है क्लाइंट का बदल गया, कोई लगता ही नहीं उसमें। मतलब
बेसिकली अल्टीमेटली हम लोग केस एकेडमिकली डिसाइड करेंगे, अल्टीमेटली कुछ होने वाला तो क्या ही है।
वेरी आई से एटलीस्ट 50% क्लाइंट्स जो है वो लोग कॉन्ट्रैक्ट में रहता है, बाकी 50% जो 2015 and उससे पहले क्या हुआ।
Actually, you don't expect. Your phone number has also changed, isn't it?
No, my phone number has remained the same.
Okay.
Item 25, SA 134 of 2023.
Yes.
Lord, this is defendant's second appeal. Plaintiff has instituted suit for declaration of title, for recovery of possession, and also, my Lord, for the declaration that the Bakshit Parcha, which was issued in the name of the defendant, is illegal. It was actually it was not the relief read for earlier. It was added by virtue of amendment in the plaint. The plaintiff, Your Lordship, claims the suit property by virtue of a gift. Gift. Parties are Muhammad. So Muhammad law will apply. Gift deed is a registered deed. Their case, Your Lordship, is that the property was one of Jumban Mia. He was the recorded tenant, and it is house property also, land and house property. Jumban Mia had one son, Ismail. After his death, Ismail inherited the property, and way back in 1962-63, by virtue of two sale deeds, 61 and 64, by virtue of two sale deeds, MD Ismail transferred the property in the name of Sheikh Ahmad Ali Ansari. And Sheikh Ahmad Ali Ansari transferred by virtue of gift. See, he gifted the property to daughter-in-law, Bibi Jaitun Nisha, who is the plaintiff, and along with his son. There stand.
And also to the son?
No, but only
the daughter.
Daughter-in-law, out of love and affection.
Gift was acted upon?
They have said that it was acted upon. Their case, Your Lordship, that the defendant was a tenant under Sheikh Ahmad Ali, and he used to pay rent to him. And after execution of gift deed, he stopped making payment of it. That was the reason, one of the cause of action for institution of the suit.
He paid rent to the daughter-in-law also?
Yes.
Did he pay rent to daughter-in-law also? Defendant. Defendant, after death of Ahmad Ali,
Yes.
he paid rent to daughter-in-law
No,
also.
no, no. Our specific case is that actually it is the Jumal Mian who had permitted us to construct house. And in the survey records of rights also, to one Nabida, her name is.
Have you denied tenancy completely?
Yes, yes. Even an issue has been framed, and the learned trial court has recorded a finding that there is no landlord relationship. So basically, issue in this particular case is that the delivery of possession has not been effected.
Arising out of gift.
Out of gift. And
Any mutation done?
So far as the mutation is concerned, they claim that actually it was mutated, but we have objected once it was rejected also. We are in possession of the property since long.
No, maybe, but mutation was done.
Mutation
And you
was-
objected also to the mutation.
Mutation.
Your objection was also rejected.
No, their mutation was rejected.
Their mutation
Was rejected.
upon your objection.
Upon my objection. And later on a Bashit Parcha was granted in mine. And
Basit Parcha in whose favor?
in favor of the defendant.
Defendant.
And they had challenged this Bashit Parcha before the deputy commissioner.
What is the date of the Basit Parcha?
The Bashit Parcha, it is 1994.
How can Basit Parcha be issued in connection with the private property?
Yes. Bashit Parcha?
In connection with the private property?
No. But yes, that is not barring law. It can be. Actually, it is the Bashit Parcha is issued for the private property only.
No, with respect to third party. Because the lineage is Jumman Mia, then Ismail Mia, he sold to two souls by two
Yes,
sale deeds to Sheikh Ahmed.
Sheikh Ahmed.
Right?
Sheikh
And
Ahmed.
then he gifted it. So Sheikh Ahmed became the absolute owner of the property. Correct? And then he gifted it to his daughter-in-law.
Yes.
So even if, let us assume that the gift deed was not there, let us
Yes.
assume for a moment.
Yes.
Then also the property will devolve upon them.
But the question is that so far as I am concerned, I am being a defendant, I am in concern. It is not in dispute that the property is of human. It is a recorded tenant.
Yes.
And in the records of rights also, my name as an illegal occupant, my mother's name, Nabila, is existing in the records of rights. And it has come on record that we are in possession way back since 1950. Since 50 years we are in possession. These things are not in dispute. So far as the Bashit Parcha is concerned, they have not implemented even the deputy commissioner as a party or any circle officer as a party. And apart from that, Section 18 of the Bihar Privilege Tenancy Act bars also the civil suit. That also bars also civil suit.
So you are claiming Basit Parcha, is
I am
it?
facing Bashit Parcha.
Which according to you it's a bar civil suit.
That Bashit Parcha cannot be challenged by virtue of a civil suit, though they have taken a ground that actually it is the deputy commissioner has allowed them to has said that you participate, and because the civil suit is pending, he will not exercise his jurisdiction. That even will not confer jurisdiction, because it is the Bashit Parcha once granted can only be considered by the deputy commissioner. And unless and until it is obtained by fraud, even if there is a procedural irregularity, procedural irregularity and fraud, these are two different terms. I will show it from the records itself, my lord, that notices were issued, and appellate court has had also, but he has showed not in the proper form it has been issued. These are the issues he has taken. Question is that Bashit Parcha, he has interfered with the Bashit Parcha without giving opportunity to the any of the persons who have issued that. So
After issuance of Basit Parcha, there is also issuance of rent receipt.
Rent receipts
in connection with that
say
Basit
that
Parcha.
we say that rent receipts have been issued,
But,
Any exhibit?
But I have seen that those are not on record. But the cases of the mutation cases are on record. Mutation cases I have brought on record. And Deputy Commissioner has passed an order that the rent receipt is state. That order is also on record. State, not cancelled. So, and it is not in dispute.
He passed an order that the issuance of rent receipt
In the
is
name of the defendant is
state till the disposal of the suit. Till the disposal of the suit, I suppose.
Yes, and because a civil suit is pending, so it is not proper for me to pass any order. This is what is the finding of the
So he himself has doubted about the issuance of basket purchase.
He could have cancelled it. He was the competent authority. Civil court has no jurisdiction. Civil court has no jurisdiction to cancel unless there is a element of fraud. If
What is the exhibit basket purchase? Which exhibit is that?
It is exhibited. Entire order sheet is. And gift is also not valid. And because there is no actual delivery of possession or the construction. Their case is their specific case is that I was a tenant under Ahmad Ali. I was a tenant. I used to pay rent, and after gift deed, payment of rent, and because it was stopped, but there is no rent receipts is on record. So unless there is a rent receipt on record, either of Ahmad Ali or any of the payment of rent receipts by myself to the plaintiff, so far as the delivery of possession.
Where is the finding with regard to landlord-tenant relations?
Yes. That part has not at all been discussed by the appellate court.
So you said that there is a finding. Where is that finding?
I am coming to it. Your Lordship may kindly see first the issues of the trial. Internal page 11, page 4 of internal page 4, page 11 of the memo. My Lord may kindly see issue number 8.
Yes.
क्या वादी एवं प्रतिवादी के बीच विवादित मकान के संबंध में मालिक एवं किराएदार का संबंध है? My Lord may kindly see the finding. My Lord, internal page 15, my Lord, at running page 22, my Lord may kindly see. विवादक संख्या 8. वहाँ तक वादी एवं प्रतिवादी के बीच विवादित मकान में मकान मालिक किराएदार का संबंध है। पक्षों द्वारा न्यायालय के संबंध में इस बिंदु पर कोई दस्तावेजी स्वरूप प्रस्तुत नहीं किया। यद्यपि वादी की ओर से परिचित कराए गए साक्ष्यों में अपने साक्ष्य में प्रतिवादी का वादी के किराएदार होने के संबंध में मौखिक साक्ष्य दिया गया, परंतु इन साक्ष्यों में द्वारा वादी के प्रतिवादी के बीच में रिश्तेदार दिए जाने अथवा कोई किसी तरह की असर में स्पष्ट किया। अतः वाद के तथ्यों और परिस्थितियों के आधार पर वादी के विरुद्ध साक्ष्य देना। तो फाइंडिंग इज अगेंस्ट दैट. So neither the constructive possession nor the actual delivery of possession. So gift was not acted upon as per the appellant. And we are still in possession of the property. But I have also filed an IA application for a stay of the execution. This issue was not even, my Lord, taken up by the appellate. Appellate court, my Lord, had.
Second appellate.
Yes.
With the leave of my Lord, in item number 4 minutes, the office note 18 January 2025 says that the respondent number 20 have died. That note is there, my lords. So up to that extent, that may be modified.
We'll see that. देख लीजिएगा ऑफिस नोट के अनुसार 20 भी बोल रहे हैं इसमें है.